Perfect. Okay. Just checking our hand signals. All right. Good morning. Today is Thursday, January 20th, and this is the time and place for the regularly scheduled Nevada Gaming Commission meeting for the month of January. Please rise and join me in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, Madam Secretary, has our agenda been posted in accordance with the open meeting law?
Yes, it has.
At this time, I would like to remind anyone coming to the podium to speak, we ask that you speak directly into the microphone and speak as clearly as possible, as this meeting is being transmitted electronically and being transcribed. Madam Secretary, let's proceed with our first agenda item, public comments.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters.
All right, anyone who wishes to address the commission may do so at this time. Matters brought to our attention during the public comment cannot be acted upon, but we are happy to hear comments of the public as well as my fellow commissioners. Comments by all will be limited to 3 minutes as a reasonable time, place, and manner restriction. If any of my fellow commissioner or myself ask questions of the public, the time needed to address those questions will not be held against those time constraints. I will first go to Carson City. Anyone wishing to make a public comment, please step forward to the podium. Let's see. You see anyone? All right, there being no one in Carson City, anyone in Las Vegas? There being no one, that will close our public comment section. Madam Secretary, the next item on our agenda is the approval of the prior month's disposition.
Pursuant to NRS 241.035, this item is the consideration of the approval of the Nevada Gaming Commission disposition for December of 2020.
All right, each of us has had the opportunity to review the disposition. If there are no questions, does anyone have a motion?
Yes, Chair, I move for approval of the prior month's disposition as read into the record by Madam Secretary.
Any discussion? There being none, all in favor say aye.
Aye.
And there are none opposed. All right, we have no items on non-restricted consent this morning. Madam Secretary, please read in the restricted consent items.
Your items on restricted consent agenda this morning are items 7, 8, 10, 11, 12, 15, and 16. The recommendation of the Gaming Control Board is for approval with the conditions as noted on the agenda. For the record, item number 1 was referred back to staff by the Gaming Control Board, and items 9 and 13 were removed from the agenda. I believe we have a disclosure and a recusal on these items.
Commissioner Brown?
Thank you so much. In connection with restricted item number 15, Century Gaming Technologies may be related to Century Games PTE Limited, a client of Louis Roca, the firm where I am a partner, in which matter I'm not personally involved. I make this disclosure in an abundance of caution because of the similarity of the names. I have no pecuniary interest in the outcome of this agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. As to restricted item number 11, my husband David Brown represents the applicant, and I therefore must recuse myself from voting on that specific matter.
All right, thank you. So if there are no questions, I believe this is, perhaps we could break it up into 2 motions. One that involves the matters that Commissioner Brown will be voting on, and one item being held out for a separate vote.
Thank you, Madam Chair. I move for approval of restricted items number 7, 8, 10, 12, 15, and 16, as read into the record by Madam Secretary and recommended by the Gaming Control Board with the conditions imposed thereon.
Sorry. All right, any discussion on the motion? There being none, all in favor say aye.
Aye.
Aye. There are none opposed. Is there a motion on the matter for which Commissioner Brown is recusing?
Sure. I move for approval of restricted item number 11, as read into the record by Madam Secretary and recommended by the Gaming Control Board.
Any discussion on that motion? There being none, all in favor say aye. Aye. There are none opposed, and the record should reflect that Commissioner Brown did not participate in the vote or any discussion on this matter. At this time, Madam Secretary, I believe that brings us to our non-restricted agenda items held out for discussion. Please read in non-restricted number 1.
Non-restricted number 1 are the applications of Jean Robert Carano for licensure as the manager of GPEG 1 LLC, the application of GPEG 1 LLC for the transfers of interest as noted on the agenda, the applications of GPEG 1 LLC for licensure as sole manager of Silver Bullet of Nevada LLC and Tamarack Crossing LLC. You also have the applications of 4GC LLC and Pegram LLC for the pledges as noted on the agenda. The recommendation of the Gaming Control Board is for approval with the condition as noted on the agenda, and I believe we have a recusal and a disclosure on this item.
All right, at this time, Commissioner Keycapper, if you want to go first.
Yeah, thank you, Madam Chair. I need to disclose for this matter that I'm an employee of law firm McDonald Carano, and numerous partners from my employer were involved in this matter, although they're not hearing today. I still believe that based on this pre-existing relationship, I should recuse myself from this matter. Thank you.
All right, at this time, I have a disclosure. One of the counsel in this case, Mr. Nylander, is in a firm for which I have alternative dispute resolution business with a different member of that firm. As I previously disclosed, I engage in mediation and allocation work and actively litigated and resolved matters. In these cases, my services are compensated by the parties or their insurance carriers and not their attorneys. I have no professional or personal familiarity with any of the entities or persons on this item, no pecuniary interest in the matter, and I conclude that the independence of judgment of a reasonable person under these facts would not be materially affected by this relationship, and because this is not a clear case of disqualifying conflict of interest, I am going to be voting in this matter. All right, so who do we have here?
Good morning, Chair Tagliati. My name is Sev Carlson with Kemper Kroll, and I'm appearing today with my co-counsel, Dennis Nylander. And good morning to your fellow commissioners. If I may, I'd like to introduce the primary applicant today, Mr. Mike Pegram. He is the majority owner, operator, and chairman of the board of managers of GPEG 1, which holds 7 non-restricted gaming licenses here in Northern Nevada. He last appeared in front of you in November when the board and commission licensed his grandson, Nate Peach, as a key employee and equity holder. We'd also like to thank the commission today for allowing us to appear in your Carson City office. Also via Zoom is Mark Rubenstein, who's counsel for the sellers in this transaction, if you'd like to take his appearance for the record.
All right, I appreciate your appearances today. As I think you all know, open meeting laws prohibit us from discussing or deliberating on this matter, and so I need to have your appearances just so that our commission members have the opportunity to ask any questions they may have of you regarding this matter. And so I'll open that up for questions or comments. I think we have significant amount of materials in this matter, particularly helpful diagram. Appears to be fairly straightforward, and the board discussed that as well, straightforward layout. Not anything? Yeah.
I just had a quick question. I believe I know the answer, but I just want to confirm for the record. The settlement that was entered into on September 29th of 2021, that resolved all disputes between the applicants and the Pierce parties, correct? Pierce Sullivan parties?
Correct. This settlement resolved the dispute between the what's been referred to as the majority ownership group and the minority ownership group, which culminated in this transaction. Or in the minority group are the sellers.
Excuse me one second.
Seth Carlson.
Excuse me one second. Do we have any idea where that's coming from?
Mr. Rubenstein, can you please mute? We're getting a lot of feedback.
Well, I don't hear anything, so that's a good sign. All right. Sir, could you please repeat what you were saying? I apologize, but we couldn't hear it.
No problem. This is Sev Carlson for the record. Correct. The settlement resolved all the disputes between what have been termed the majority owners and the minority owners, culminating in the transaction that's before you today, wherein the minority group are the sellers and the majority group are the buyers. So it's a member-to-member transfer.
Thank you very much for clarifying that. I thought that's what I understood, but I wanted to make sure. With respect to the properties, will this transfer affect the operation, the day-to-day operations in any material respect?
No, the day-to-day operations will remain the same. We have GPEG's Board of Managers. One of the applications before you is for Gene Carano to be licensed as a manager. He's been licensed by the commission on numerous occasions, but day-to-day operations will remain the same. Mr. Pegram's heavily involved on a daily basis, as are Rick Murdoch, who's another member of the Board of Managers, and the balance of the management team for each of the locations remain the same.
Thank you very much. I don't have any concerns. I do agree that it's pretty straightforward, so I would pass to anyone else with questions.
Thank you. Commissioner Cohen?
Thank you, Chair. I just want to follow up on Commissioner Solis Rainey's comment regarding the arbitration that was ultimately resolved September 29, 2021. Was that arbitration, in litigation strictly on the interpretation of the buyout and money, or were there other issues that were raised in that litigation?
It was strictly on the buyout provision provided for in GPEG 1 LLC's operating agreement.
So it's centered around interpretation of how much would be paid under the exercise, correct?
A combination of value, and then a combination of how that buyout provision works in terms of who's a buyer or who's a seller, and the timeframes associated once that option is exercised to determine whether one group wants to be the buyer or the seller. But essentially that's all kind of wrapped into one. But I think there was a little nuance beyond the purchase price as to the timing of who's a buyer or who's a seller. And ultimately the parties resolved that in determining that the minority group would be the seller and the majority group would be the buyer.
Thank you for that. I appreciate that. I have no issues with the application.
Any other questions?
Just briefly, as a point of clarification, I note that the GPEG's loan from Citizens Bank exceeds the purchase price and that there's a 5 million revolving credit facility. Can you explain if the revolver will be used for GPEG and its subsidiaries for the working capital and general corporate requirements? And if you could explain what the general corporate requirements are, trying to understand the delta.
Okay, and I'll let Mr. Pegram speak to the financing. He's been involved in that on a day-to-day basis.
Thank you.
Good morning. The delta between the citizens loan and the buyout was the underlying mortgage on the properties going into the dispute. The drawdown on the revolver is all of our costs associated with the loan and the legal cost with this matter.
Thank you so much for putting that on the record. I don't have any other points of interest at this time, other than I note that one of the conditions related to the fully executed promissory notes and the credit agreement, they must be submitted to the board within 60 days. Is that still your understanding?
Yes, that's our understanding, and we will comply with that condition.
Thank you so much. I have no further questions.
All right. There being no additional questions, I think at this time it's proper for a motion.
And Chair Togliatti, I'd like to raise one point. It's not directly related to the applications, but just to update the commission. We regret to inform you of the passing of Lud Correo, who was a longtime licensee and member of GPEG. The interest described in this application will pass to his family trust, which is fully registered and licensed by the commission. Together with Mr. Correo's successor trustee and gaming counsel, we have been in contact with board staff to ensure that GPEG is in full compliance with the provisions of Regulation 9.
Well, we certainly, as a commission, offer our condolences to Mr. Correo's family, friends, and colleagues, and thank you for that. Does anyone else have any questions or comments in light of that additional information? All right, there being none, does anyone have a motion?
Thank you, Madam Secretary, or Madam Chair. Just a quick question with respect to, I do have a motion, but Mr. Rubenstein, were you interested in making an appearance on the record? I don't know that we gave you the opportunity or that you took the opportunity to do.
Thank you. I would like to, on behalf of the sellers and transferors, nothing to add to the presentation. Thank you. And I apologize, if my video is not coming up and I don't understand why.
Okay, we're also having, maybe someone else understood that, but I didn't.
No.
So we didn't, I apologize, but the audio the quality is very poor such that I don't know what you said. Is there a chance you could repeat it? for
Yes,
us?
can you hear me?
Yeah, it's just very garbled, I guess is what I mean. Did you understand what you said? You believe what you, can you restate it and he can confirm?
Mr. Rubenstein, I believe you indicated you did want to make an appearance on the record on behalf of the sellers.
Yes,
Thank you. With that, I would move for approval of non-restricted item number 1 as read into the record by Madam Secretary and recommended by the Gaming Control Board.
Is there any discussion on that motion? There being no discussion on the motion, all in favor, please say aye.
Aye.
And there are none opposed. On the record should reflect that Commissioner Keycapper did not participate in the discussion on this matter or the vote. Thank you, council, for your appearances today. And we appreciate you being here. And again, the commission's condolences for the passing of Mr. Correo.
Thank you, Madam Chair. Thank you, Commissioners.
At this time, Madam Secretary, could you please read in non-restricted number 2?
Non-restricted number 2 is the application of Every Holdings, Inc. for an amendment to their order of registration. You also have the applications of Every Holdings, Inc. and Every Games Holding, Inc. for the pledges as noted on the agenda. The recommendation of the Gaming Control Board is for approval.
Good morning. I believe we also have someone via Zoom.
Do we have a Zoom appearance?
Yes, Mark Glabai here, CFO for Every is here.
Yes, we see you and we hear you. Thank you
Perfect.
for that, stating your appearance.
Excellent. Thank you. Madam Chairwoman, members of the commission, Madam Secretary. For the record, my name is Kate Lowenhar Fisher, and I am the General Counsel of Every. With me today via Zoom is Mark Labai, our Chief Financial Officer. I must confess I was calling him Typhoid Mark today because he is in quarantine, which is why he's over Zoom. And but fortunately, he's feeling relatively well. So
Yes.
I'm relieved to hear that. This application is for an amendment to our order of registration and an application for certain pledges in connection of a refinancing of our debt that was consummated in early August. Certainly, we're here to answer any questions the commission might have. And Mark is, of course, available to answer the financial questions if the commission has any of those.
Okay, thank you. I'll start on my left and work my way. Commissioner Brown, do you have anything?
I was hoping just for a short affirmative presentation, if that's possible. I think that should answer any questions I might have, if that's
Sure,
acceptable.
absolutely,
Thank you.
Commissioner. I think Mark was actually going to be the best situated to give just a brief explanation of the refinancing and the circumstances and why we did it.
Yep, absolutely. Thanks, Kate. For the record, Mark Labai, Executive Vice President and Chief Financial Officer. We did conduct this refinance in early 2021, started in April. Through the pandemic, we acquired some incremental debt that was at less than favorable rates just due to the timing and the amount of shutdowns. And as we were progressing through 2021, our financial situation started to improve substantially as casinos reopened, as the industry got little tailwinds behind their back, and it was an opportune time to relook at the entire capital structure. Some of the old debt that had been on our books for 5+ years at that point, as well as the incremental term loan that we acquired. So we endeavored to redo the entire cap structure, lowering our total borrowings from 1.1 billion about down to $1 billion, and recharacterizing the split of the debt between term loan and unsecured notes, with $600 million of term loan and $400 million of unsecured notes. The remainder of the balance of the debt that we had prior to the refinance was funded or repaid with cash on hand on the balance sheet at that point in time. Effectively, what that did for us in terms of interest rate was lower our cost of borrowings by about 150 basis points, and extended the maturity dates of our term loan and our unsecured notes. Also, as part of this process, we endeavored to expand our revolving credit facility to provide us more working capital in case operating needs so arose, or unfortunately, if another pandemic were to come around, we'd have a little better base from which to fund our operations and have stronger liquidity position. So we expanded from a $30 million revolver to a $125 million revolver as part of this. So really just getting our balance sheet in a much better position post-transaction than pre-transaction was the result of this transaction.
Thank you so much. That was very helpful. And I think it's very wise, of course, to look at things big picture, not be myopic, and think of the financial health of the company. If somebody could please provide me with an update on the Texas litigation. I know when I viewed the presentation before the board, it was in its infancy. If there's any kind of detail you could provide or an update in terms of what's happening there.
There's not really any substantive update that I could provide since then. Of course, we are going to vigorously defend ourselves in any litigation that's facing the company, and it's one of the parts of doing business.
And that's a patent infringement case?
Yes.
Okay. I have no further questions. Thank you so much for that presentation.
Thank you.
Commissioner Cohen, do you have anything?
No, the presentation helped regarding the refinancing, and it's well done, especially the markets have moved since you locked in those rates.
Indeed.
Yeah, thank you.
I also didn't have any questions. It seemed pretty straightforward and made sense to me. I just want to confirm that the 9th revised order registration is what is before us.
Yes,
And you've reviewed that and have no problems. I believe the draft dated was 12/14/21.
correct. I've reviewed it, have no objection.
Thank you. And did I hear a new title for you?
It's
It
so
flowed out
long.
differently than during the board.
Right. I need like an 8x10 business card. Executive Vice President, Chief Legal Officer, General Counsel, and Secretary.
Well,
So I get paid by the title? No, I
Yeah.
Well, congratulations to the
Thank you.
legal officer, I think is the one I was used to
Yeah.
hearing. So I
Thank
think
you very
it's a
much.
change there. And Mr. Lebe, I'm glad you're feeling better.
Thank you.
It seems this is something, we're
I'm
having
on
to
the
deal with
tail end
quite a
for
bit,
sure. So I'm excited to be through this process.
I'm sure.
Yeah.
I don't have any further questions, Madam Chair.
Commissioner? All right, I also don't have any additional questions. I appreciate you being here today, and Mr. Laba, I hope you recover. I think we have everything we need unless there's anything else. For a motion.
Thank you, Chair. I would move for approval of non-restricted agenda item number 2 is read into the record by Madam Secretary and recommended for approval by the Gaming Control Board, and authority for Chair Tagliati to execute draft number 1.
That's the December 14.
Yes.
Yes.
Yep.
Any discussion on the motion?
No.
There being none, all in favor, say aye.
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 And,
Sorry.
okay, and it appears there are none opposed. Thank you very much. Thank you.
Thank you.
Thank you.
Thank you. Have a good day.
Madam Secretary, please read in non-restricted number 3.
Non-restricted number 3 are the applications of Yale Frederick Rowe for licensure as a key executive and key employee of NEVA 1 LLC. The recommendation of the Gaming Control Board is for approval, and I believe we have a disclosure on this item.
Yes, thank you so much. Brief disclosure. Mr. Rose, potentially adverse in a matter for a client of Lewis Roca, the firm where I am a partner, in which matters I am not personally involved. I have no pecuniary interest in the outcome of this agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. Thank you.
Thank you. Excuse me, good morning.
Good morning, Craig Gimignani, from the law firm of Dickinson Wright on behalf of Mr. Rowe for his application as a key employee of the Hard Rock Hotel Casino in Lake Tahoe. And good morning, Chair Tagliani, Commissioners, and Madam Secretary. Diana Bennett is also here in support of Mr. Rowe's application. In addition, we would respectfully request to withdraw without prejudice the applications related to his company Front Row for the same position. Oh, I'm sorry, that's not on here. As you know, Mr. Rowe is a seasoned veteran of the gaming and hospitality industry with his experience at multiple gaming properties in the last 20 years, including Great Valley Ranch, Hard Rock, Las Vegas, Paragon Gaming, Silverton, and he's been a consultant to gaming and hospitality operators. And again, today he's asking for approval of his application as a key employee of the Hard Rock Hotel Casino Lake Tahoe. And with that, I'll ask Mr. Rowe to introduce himself.
Good morning.
Good morning, Yale Rowe. Thank you for having me today. It's a privilege.
Okay, so I would note that you successfully made the withdrawal for the board, so that matter has been resolved at this time. I have had an opportunity to observe the meeting and also read the transcript of the board, and am very impressed with your significant breadth of gaming experience. I'm going to open it up, I think, to my fellow commissioners here, and how about I start on the right this time? Commissioner Keycover?
Yeah, thank you. Can you talk just a little bit about the decision to make the change from the onboarding the corporate entity to rather coming back in as an employee?
Sure. Miss Diana Bennett told me to do that. we had discussed, sorry about that. We had discussed engaging Front Row, which was interesting to me to potentially have that entity come through this channel. And Diana had a preference of me becoming a team member at the property, which I was also fine with. So we made that decision, of course, after I originally had filed my application. So we adjusted at that point.
Obviously, this is a really important property to the Lake Tahoe market. Just talk a little bit about how the operations are currently and
Sure.
Sort of what you see in the future.
Sure. I've been in the market approximately a year, a little over a year. First 5 months or so as Front Row, and then for 7 months or 8 months as an employee, team member. Really interesting market. I thought I've seen a lot, and then I showed up in Tahoe, and of course COVID was fast and furious, which created a pretty significant challenge there. Not as I originally expected. California, which if you've been to South Lake Tahoe, is 100 feet away from the casino properties, and California was essentially closed shortly after I got there. Meaning the restaurants were closed, gatherings were closed, everything was closed. So all of those folks drifted into our properties for any type of entertainment and dining and beverage and gaming, of course. So we were generally overwhelmed for quite some time, and we had a lot of restrictions when I was there, 25% capacity in the outlets, which created these tremendous waits and a whole bit. So it's a really interesting scenario that was unfolding. Business was robust from a volume standpoint. Summer is the primary season there, so July and August are huge months. And then, of course, if you recall, in mid-August, we had a huge threat from wildfires in the area, to the point where 30,000 people were evacuated out of South Lake Tahoe. They never ever imagined that would occur. And we operated through that. We closed the casino, but we housed a lot of the emergency personnel. We housed U.S. Forest Service, became kind of the central hub for emergency services. That lasted for probably close to 2 weeks. Took a little bit of momentum away from the market as a whole, and then October bounced back very quickly. And then most recently, with ski season started off quite slow. We didn't have any snow early December, and then it all showed up at once, and we had an enormous snowstorm day after Christmas, and that created a whole another set of challenges in the property. But the market's doing quite well. There's an event center in South Lake Tahoe that's about a year away from opening. So you can see the steel the whole bit. That'll be a game changer for the market. And we're expecting, it's 100 feet across the street from us. So we're expecting that to change in a positive way a bit our market mix for the hotel. We'll see probably more business, more special events as it relates to concerts and sporting type events, which you guys are certainly very familiar with down here. So Hard Rock as an individual property has had a great success in the last 2 years. Prior to that, a bit of a struggle. I was consulting for Paragon Gaming in 2015, 2016. Excuse me, when I brought that that asset to Paragon as a potential management arrangement, and then lo and behold, it became an acquisition for Paragon. And I think Diana would tell you it was a pretty rough 3 or 4 years, and then the business model started to evolve and pick up, and now it's quite robust.
I appreciate that. Thanks very much.
Good morning. Thank
Morning.
you for being here today.
Thank you.
Well, I have to tell you, your response to Commissioner Kiefer's first question tells me a lot about your judgment. It's good that you listen to this supportive employer that you have, and Ms. Bennett is a great person to have behind you. I wanted to commend you. I remember during the fires hearing the name of your property quite a bit, and I know you took quite a lead role in making the property available to the first responders and such. So I think that says a lot about the character of the company.
Yes.
And I just wanted to take a moment to commend you for that. I didn't have any questions regarding your application. It's always great to see a fellow rebel doing well.
Thank you.
So I have no problem supporting your application and would just pass it.
Just a quick comment on on the fire and our response. Diana is incredible when it comes to those type of scenarios, and as much as it impacted our results in a negative way, we have a fantastic team there, and they really all stepped up. A handful of them did have to evacuate because they lived in a particular area that was really in danger, and some of those actually packed their families and went west to Bay Area or whatnot. But a lot of them checked into the property and stayed and came down and helped us. We were all in the kitchens cooking. We probably had 25 people with 100% occupancy. So we're trying to feed people and trying to keep the place somewhat presentable. But everybody was very, very grateful, those folks, and very patient with us. Where we got through. Our team really did step up. I'm very, very proud of what they did there.
Commissioner?
Thank you so much. I simply echo that. You're a wonderful community partner. It's so good to see people leading by example, and I think it's going to be a wonderful partnership with the community. So thank you for the wonderful presentation and for coming today. I have nothing further. I support the application.
Thank you.
Again, thank you for your appearances today. And if there are no more questions, it appears that your agenda item is ripe for a motion.
Thank you, Madam Chair. I would move that we approve non-restricted item number 3 as read into the record by Madam Secretary and approved by and recommended by the Control Board.
Is there any discussion on the motion? There being none, all in favor, say aye.
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 And it appears there are none opposed. Congratulations. Thank
Thank you
you.
very much. Appreciate it.
Thank you. Madam Secretary, please read in non-restricted number 4.
Non-restricted number 4, the applications of Roy Liebador and David Drew Ross for licensure as a key employee of 777 Game LLC, and the application to add, remove, or modify a condition. The recommendation of the Gaming Control Board is for approval with the removal and addition of conditions as noted on the agenda. And I believe we have a disclosure on this item.
Thank you so much. I have a disclosure for non-restricted number 4. Mr. Ross is a principal officer of Affinity Gaming, a client of Louis Roca, the firm where I'm a partner, in which representation I'm not personally involved. I have no pecuniary interest in the outcome of this agenda item. I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. Thank you.
Thank you. All right, good morning.
Good morning, Madam Chair, members of the commission, Madam Secretary David Ross, 900 South Carson, and I believe up in Carson City, I have Randy Sayer and my partner Roy Bedore, which I'd like to turn it over to Randy, if that's okay.
Okay, Mr. Sayer,
Thank you,
when
David.
you're ready.
Chair, yes, I am ready. Chair Togliatti and members of the commission, we've got two, and we've got the only two principals in this organization in front of you today. Mr. Bedore up here in Carson City and David Ross standing in front of you down in Las Vegas. I know that the commission has had the benefit of the transcripts from the board as well as the investigative material. So rather than revisit an introduction in that regard, I make myself and both of the principals available for any discussion or questions the commission may have. Thank you.
Okay. I'll start to my left. Commissioner Brown.
If I could just please have a very brief presentation of the roles and how much time is spent where, I think it would be helpful and it would probably streamline the line of questioning that I might have.
Sure.
Thank you.
Roy, do you want to go? And then,
Good morning, Madam Chair, Commissioners, Madam Secretary, Roy Bedore, 777 Game, 900 South Carson. We do have a GM of the property. David and I are also very involved in the day-to-day operations. I actually have moved to Northern Nevada just recently, so I'm actually even more involved in the day-to-day operations of this property. David became my partner in October of 2018 on the casino side of the property. I own the real estate, the hotel, the Blackbird Diner, and then David is a partner on the casino side. So we are, we have weekly meetings with all our staff. We have monthly financials. We go through all of that stuff. So we are very involved in the day-to-day operations.
I would add, if I could, commissioners, that in addition to the weekly meetings, in the financial reviews, we monthly slot reports. We look at bank balances every day, check registers. So it's much more oversight than probably most, even from a compliance standpoint. We have separate compliance meetings. And so we take the role very seriously as the gold standard of Nevada in our privilege to do that. So for the oversight, I would just say that it's probably, right at best practices from what you would think.
It sounds like you do, and I observed that before the board, and I just wanted that as part of the record because I think you all take it very seriously and you spend a lot of time on the day-to-day operations and not only being on site, that's just one component of the management. So
right.
I thought it would be nice to have it on the record, but I have no areas of concern at all, and I support the application. Thank you.
Commissioner Cohen.
It's a very clean application. I think you guys are well suited, and I'm also in support of the application. I have no question.
I don't have anything further either. Your presentation, covered the overview that I was hoping to hear, and I think this is very clean and I'm happy to support it.
Nothing else? I agree with my fellow commissioners. Past investigations, all clean. This looks good to me, and I think we're ready for a motion.
Thank you, Madam Chair. I would move that we approve non-restricted item 4 as read into the record by Madam Secretary and recommended by the Gaming Control Board.
All right, any discussion on the motion? There being none.
Well, I'm so sorry. Do we need to add anything about a key employee application for the position of the general manager to be refiled within 60 days of any change? Is that something, I observed that in front of the board. Is that anything we need to put on the record relating to that?
You can ask. I don't think so. I thought it was part of the recommendation.
Okay.
Came up to have that condition altered. Yes.
Thank you.
Okay.
Thank you.
Then the motion stands as is, and there being no discussion, all in favor say aye.
Aye.
And it appears there are none opposed. Thank you very much for your appearances today. Thank you in the north.
Thank you.
Thank you,
luck.
Madam Chair. Thank you,
Thanks.
commission members.
Okay, Madam Secretary, please read in non-restricted number 5.
Non-restricted number 5 is the application of the Vanguard Group, Inc. for the waivers as noted on the agenda. The recommendation of the Gaming Control Board is for approval. And I believe both appearances are via Zoom.
Okay. Do we have someone on Zoom? You could state your
Yes, we
appearance.
do. Yes, we do. Chair Tagliati, Commissioners, Madam Secretary, Sean McGinnis with Butler Snow on behalf of the Vanguard Group. And I also believe via Zoom is Glenn Borum from the Vanguard Group as well. He should be on. I see him there. So what I thought I would do, if it's acceptable, is sort of give you a little overview and then hand it over to Glenn to sort of describe the Vanguard Group. Because what we have here is we have a renewal of a institutional investor waiver. And so there's an order related to it. When Vanguard first got their institutional investor waiver, that was done before any of the commissioners that sit presently were on the commission. So this is the first time that you would have seen the Vanguard Group, similar to the board. The board was, since the 3 years have gone by, the commission members and the board members have all turned over completely. So if that's acceptable, I could hand it over to Mr. Borum. Does that work?
Yes, thank you.
And one thing I should add is, and Madam Secretary should have provided, there's a PowerPoint that was provided to the board to follow along or to reference with when Glenn's making his presentation. We would ask that be deemed confidential. It's not, and so not part of the record, just deem it to be a confidential aspect of the hearing, just like we did at the board. So with that, I hand it over to Glenn to make a presentation. Glenn?
Great, thank you, Sean. And good morning, Chair Tagliati, Commissioners, and Madam Secretary. My name is Glenn Borum, as Sean said, and I'm a principal at the Vanguard Group. And I'm grateful for the opportunity to testify before you today to seek the renewal of our order that was granted back in January of 2019 for waivers of our waivers as a result of our institutional investor status. As a brief overview today, I'll first discuss Vanguard generally and then go into a little bit of detail on our investment approach and how we vote securities that our funds own. As you may know, Vanguard's a U.S. registered investment advisor whose mission is to take a stand for all investors, to treat them fairly, and to give them the best chance for investment success. And from our start over 40 years ago, Vanguard is focused on this mission through our structure, which remains unique in the mutual fund industry today, where individual investors own each of the Vanguard funds that in turn own the Vanguard Group. As a result, we're not accountable to a separate group of public or private owners seeking profits, only to the clients who have entrusted their assets to our care. Now, in pursuit of this mission to give investors the best chance for investment success, all of the equity funds over which Vanguard has investment and voting discretion utilize either an index or a quantitative strategy. Each of these more than 200 funds that we manage has its own investment objective or mandate and its own shareholder base. In aggregate, these funds invest in businesses across a wide range of industries around the world. And in each of these cases, a fund's ownership is driven by its investment objective and is for investment purposes only, not to gain any sort of control or exert influence over the investee companies. Now, the Vanguard index funds invest in the components of whatever their specified reference index is. An example would be the S&P 500 or other indexes, which are developed and maintained by independent third parties separate from Vanguard. And by holding securities in the approximate proportions they're represented in these indexes, the funds seek to track their benchmark's performance over time. And for those funds implementing a quantitative strategy, they utilize algorithms to evaluate and select from all of the securities in which the fund might invest based on its mandate, whether that be small capitalization versus large capitalization, growth stocks versus value stocks, etc. Through both of these channels, Vanguard funds have purchased and currently own publicly traded stock issued by gaming companies that are licensed by state regulatory bodies. The Vanguard funds additionally invest in a number of companies, approximately 20, that are overseen by the state of Nevada, one of the nation's leading gaming states. Now, the fund's acquisition or disposition of these stocks is driven primarily by two things. The first of these is cash flow into or out of one of the funds whose benchmark or quantitative model includes the stock in question. Over time, our way of low-cost, long-term investing has resonated with clients, and they've entrusted more of their assets with us over time. As they purchase more of our funds, the funds purchase more of the securities in their benchmark or model. The second thing that drives changes in the ownership here are changes in the weighting or inclusion of the stock in its benchmark or model. On a periodic basis, index providers will rebalance their benchmarks, resulting in changes in their constituents and their relative weighting. In order to track the benchmark, the fund must adjust its holdings accordingly, resulting in purchases or sales of the impacted stocks. Similarly, refinements to the models in response to market events by our quantitative equity group, who manages our quantitative funds, will result in portfolio changes, buys or sells of the underlying securities over time. In all of these cases, decisions to own more or less of a particular stock in any industry are driven by client decisions to own more or less of a particular fund, or by changes in the benchmark or model that the fund is following. These ownership decisions, again, to reiterate, are not driven by an interest in assuming control or influence over the underlying companies. Now, once a fund owns a company's stock, it does have, as do all other shareholders of the company, the right to vote its shares at the company's annual meeting. As a practical matter, most shareholders typically vote their shares via proxy, as opposed to attending shareholder meetings and voting in person. This is typically referred to as proxy voting. The board of each fund is obligated to ensure that it votes proxies in the best interests of that particular fund, after taking into account that fund's investment objective and not the interests of any of the other Vanguard funds or Vanguard itself. To comply with this fiduciary duty, each board has adopted proxy voting procedures and guidelines applicable to the funds Vanguard advises. The board has tasked the investment stewardship team, an operating group within Vanguard, with the day-to-day function of voting proxies for each of the funds pursuant to these guidelines. And further, each board has also tasked the Investment Stewardship Oversight Committee, made up of senior Vanguard officers, a majority of whom are also officers of each fund, with oversight of the performance of the proxy voting function and the implementation of these procedures and guidelines. This committee reports directly to each of the fund's boards. So I'd like to conclude by confirming how seriously Vanguard takes its regulatory compliance obligations, from pre-trade compliance oversight by our risk management group to post-trade monitoring by our fund compliance team, all supported by the fund's compliance officer under the auspices of the Office of the General Counsel. Ensuring that we're always doing the right thing is part of Vanguard's DNA. We respect the important role that gaming laws and regulations play in ensuring the integrity of the businesses and people who operate them. And we're grateful for the approval of our waiver request in 2019 and appreciate another opportunity to come in front of the commission and speak on this matter. Happy to answer any questions, and thank you again for the opportunity to testify this morning.
Thank you. I appreciate your presentation. We all do. At this time, Commissioner Necker, I believe, has questions.
Appreciate that, Madam Chair. Mr. Borum, I appreciate the presentation, and I'm most particularly interested in how you vote shares. And I think I'm going to restate what I think I heard, and you can tell me if I'm right or wrong. So each individual fund votes its shares based on the interest of that fund, rather than Vanguard collectively voting its shares in the best interest of the broader entity. Is that accurate? So that there's no coordination between the funds in how they vote their shares.
Right, that is correct. Each fund has a set of proxy voting guidelines, and the investment stewardship team applies those guidelines to vote in the fund's interest. And to the extent the fund's interests are different, they will vote differently.
Okay. And no individual fund, I think what's in our application is that no individual fund holds more than 3% of any individual company. Is that accurate?
I believe that I don't know specifically about the 3% threshold, but certainly the aggregate positions are often spread over anywhere from 30 to 60 different funds.
I'll have to go back and double check my notes to see where I have that marked. But and then I guess more broadly, do you know the total value of the all of the various assets in Las Vegas that are held collectively by Vanguard, without asking you to outline individual companies?
I do not have that in front of me at this moment. That's certainly something we could compile and return back to the commission.
Thank you, Madam Chair.
Yeah, we can supplement that information for you, Commissioner.
I have a question. I understand that we're talking about up to 25% of the voting securities of any publicly traded corporation, but I think I heard at the time of the board's meeting that you seldom have a holding over 11%, something to that effect?
Yes,
There was
currently
discussion.
there are a couple of companies where we're over 10%, but just a couple of those at this point.
Right, and the reason that we've asked for the 25% is it's just, that's what we asked for last time. And it used to be before the legislature changed the percentages, that it used to be 15% cap and it went up to 25. So we're just trying to match what is statutorily allowed. So it's not necessarily saying they want to own 25% of a bunch of companies. It's just more, the percentage is more geared towards matching what the statute requires. So it's consistent.
Because in fact, I think you told the board at their meeting, and or at least I believe there was a reference to a 3-year review showing close to 10%. I recall that being part of the discussion before the board, and that's accurate?
Yes.
Okay. I don't have any questions. Did you, just moving down the line here, Commissioner Cohen?
Thank you, Chair. Are there any internal controls that would prevent you from basically tendering for a company? In other words, if you were a substantial shareholder in ABC Gaming, would it be possible for you to tender for controlling interest in that, or is there a prohibition within your charters that would prevent that?
I mean, as a registered investment company, we are prohibited from seeking control of portfolio companies.
And I appreciate that. I can tell you after reviewing your documentation, and this is the first time I've had the opportunity to review the Vanguard Group, if there ever was a company that should be entitled to the continued waiver, it's Vanguard, the way you do business. And I think we as regulators appreciate that very much.
Thank you.
Just briefly, thank you. That was a wonderful presentation. It's very interesting and demystified quite a few things about Vanguard for me, which has been around, I think, for at least 40 years. Can you explain to me just briefly the genesis story? I think my takeaway from your presentation that distinguishes Vanguard from other fund companies is that there are no outside owners and the clients keep more of the returns that each fund earns. That's my understanding. But what was the genesis story for Vanguard when it at its inception? If you could just briefly give me that background.
You mean at our inception, we were established initially as a management company to do the administrative work for a series of other funds owned, and the objective was to be owned by those funds, to really have a single set of stakeholders, not having to split the benefits between the funds who we serve and a set of shareholders. So from day one, Vanguard has been owned by the funds to which it provides both administrative and investment management services, and that has paid off over time. I believe one of the slides in the deck that we provided shows the substantial expense differential that this has enabled us to provide to our end investors, and by being able to charge only what it costs us to do business, not to generate profits for another set of owners, though that benefit accrues to the fund investors who own Vanguard as a management company.
And sir, I'm looking at page 6 of the slide, I think with the graph on the left. I believe that's what you're referring to.
Yes.
Okay. And so basically this is, I think, pretty straightforward. You just want the waiver that would expire now in January of 2025. And the first waiver was sought and obtained by the commission in January of 2019. So I have no areas of concern at all. And I commend the way Vanguard has conducted itself and has really set itself apart. So I have no further questions. Thank you.
Okay, I would simply say that previously the commission found, pursuant to Commission Regulation 16.430, that as an institutional investor, that their investment purposes don't cause directly or indirectly the election of the members of the board, directors, or affect any change in the corporate charter, bylaws, management policies, or operations of the corporation or any of its affiliates as required by our regulations. So I'm comfortable with this. And obviously the previous commission was comfortable with this. The board was comfortable with this. So if there's a motion.
Thank you, Madam Chair. I move for approval of non-restricted item number 5 as read into the record by Madam Secretary and recommended by the Gaming Control Board.
Any further discussion? There being none, all in favor say aye.
Aye.
There are none opposed. Thank you very much for your appearances today, and your materials will remain confidential as submitted. Thank you.
Thank you very much.
Thank you so much.
Okay, Madam Secretary, please read in non-restricted number 6.
Non-restricted number 6, the applications of United Coin Machine Company doing business as Century Gaming Technologies, doing business at Sahara Center for a non-restricted gaming license. The recommendation of the Gaming Control Board is for approval with the condition as noted on the agenda. I believe we have a disclosure on this item.
Thank you. I do have a brief disclosure to make for non-restricted item number 6. Century Gaming Technologies may be related to Century Games PTE Limited, a client of Lewis Roque, the firm where I'm a partner, in which I am not personally involved in connection with that matter. I make this disclosure in an abundance of caution because of the similarity of the names. I have no pecuniary interest in the outcome of this agenda item, and I do not believe the independence of judgment of a reasonable person in my position would be affected by the relationship described on the record, and I therefore intend to participate. Thank you.
Thank you. Morning.
Good morning, Chair Tagliati, members of the commission, Madam Secretary. For the record, Debbie Cornine. I represent Century Gaming in this matter. And also with me today is Buzz Horton. He is the property manager. We are here to answer any questions you might have. As you know, I've said before, these are very common one-day operations that we continue to do. And this one has been done numerous times in the past. And again, we're here to answer any questions.
Are you feeling better?
I'm definitely through the worst of it, and
Okay.
have been cleared to be in public. So
No, yeah, I understand. Not putting you on the spot, but I understood from the board meeting that you had to appear by Zoom, and you know, mm, you're part of the surge, as many of us have been. So I'm glad you're feeling better and you're able to appear today. Um, I think I started on this side. Why don't I start with Commissioner Brown if she has anything?
Thank you so much. I understand that this is the 10th time that this type of gaming operation will occur to preserve the grandfather status of the Sahara Center. Is that correct?
that is correct.
Okay, and it's just going to be the 1 day, 8-hour gaming operations for the 16 machines?
That is also correct. Yes, we will bring the games in at 6 in the morning and leave by 2 o'clock in the afternoon.
All right, and if this is not approved, it'll expire February 6, 2022, but I don't see any issue. I have no areas of concern.
And just for the record, the city has approved this. It was a consent item.
Excellent. Thank you so much.
Commissioner Cohen, anything? No. Either of you?
Madam Chair, my question relates to sort of access to the space. So there's a Walgreens on the first floor and at mezzanine level, and this operation, or is it a segregated second floor that's outside of that Walgreens space?
Yes, it is. It is on the second floor and there is access by an outside
Escalators and
escalator
elevators.
yeah.
Thank you much.
Apologies. I had just a quick question regarding the walkway. Is the proposed walkway being considered to go across Las Vegas Boulevard?
I'm sorry, what is?
I thought there was just discussion about a proposed walkway that might increase, I guess, make that property more attractive because it's a second floor
Correct.
space.
The city has proposed an oval walkway going from all four corners, so somebody can go up one walkway, walk completely around and exit on any of the four corners.
Okay. And what's the time frame on that?
I believe it was 2023, the end of 23.
Do you expect to see any movement in the property? Is the property currently for sale?
Yes.
Maybe with that on the.
And just to add a comment to that, there has been some significant activity that we're hoping to see, or they're hoping to see something take place relatively quickly.
I would think that would make it much more attractive, to have that access. So I don't have any concerns with the application, like was raised at the board meeting. I was just concerned that this has just been going on for so long, and I didn't know, what point.
Well, in all fairness, we've only been in front of you. This will be our fourth time. I know it's been 11 times, but that's when the Holy Cow was closed itself. And then we basically, my client had bought the property, tore down the building, built a building, and then obviously COVID and all the other things happened. So we hopefully don't plan on being in front of you again.
Understood, and not a criticism of you specifically. Again, it's just one of the ones that, at least during my tenure, has seemed to go on for the longest. So
Understand.
I appreciate your responses. Thank you.
Okay, I also don't have anything additional. And
Brief follow-up, if I
go
may.
ahead, of course.
To the question that was just posed in connection with the sale. How long has the property been for sale? Did you say it was for sale right now?
Yeah, I'm not part of that portion of it. Colliers International is, and I believe it's been up for about 60 days, 90 days.
Okay, have there been any letters of intent or any interested buyers without providing any details?
Again, I'm not sure.
Okay.
That would be an ownership question.
All right, I have nothing further.
Okay, is there anything else?
I'm prepared to make a motion unless there's anything else.
I don't think there is.
Chair Tagliati, I move for approval of a non-restricted item number 6 as recommended by the Gaming Control Board and is read into the record by Madam Secretary.
Any discussion on the motion? There being none, all in favor say aye.
Aye.
There are none opposed. Thank you very much.
And thank you.
Madam Secretary, I believe that brings us to our restricted item held out for discussion. Please read in restricted number 2.
Restricted number 2 is the application of Country Store LLC doing business as Country Store for restricted gaming license and the applications of Abad Malagi, Moad Ruman for licensure as member and manager. The recommendation of the Gaming Control Board is for approval with the condition as noted on the agenda.
Okay. I see we have appearances in Carson City. So at this time, would you gentlemen please state your appearances for the record?
Good morning. My name is Ubaid Mobales. I'm the current owner of the Country Store.
Good morning. My name is Mahbub Rehman. I'm the owner manager of Country Store.
Okay. Thank you for your appearances today. At this time, I believe if we have any questions from any commissioners, there might be some, I anticipated there might be some questions, but I'm not sure.
I would just like an affirmative presentation, briefly,
Okay.
just to talk about the violation of NGC Reg 8.050 and maybe just a little bit of background, if that's acceptable.
Which one of you gentlemen would like to give us some background as Commissioner Brown has requested? Did you hear what she said?
Yes, in record, my name is Ubaid Mabalag. I'm the current owner of the country store. As we were, I have so many businesses, so I decided to put the country store on partnership with one of the person that I knew for a long time and trusted that he would be a good partner in the future to take care of the country store on a day-to-day basis. And Mr. Raymond, he lives in Toronto, Canada, so we decided to see if there is any opportunities for him to come down if he can only get his visa. So when he applied for a E2 visa, which is a visa for business in United States to come in and do a business transaction. In order for him to do that, he has to go through the immigration and has to submit all the paperwork to make sure that the immigration will grant him the visa to come down to United States and conduct business. So according to his lawyer, that he needs to make sure that every step has to be done properly by him to get approval. And the money that we agreed that I would sell the 50% of my business to him, that money has to be transferred in order for him to get the visa. So when they, in that condition, before we even make any business deal, we had told him that since I carry a restricted license for gaming, I cannot do any kind of contract unless the gaming approves him for this, being a member of the country store or managing partner at the country store. So once the lawyer told him that he has to send in the money to my account, which was the country store account. So they sent the money into the country store account, and at the same time we came in and we filed the application with the gaming to make sure that we both get approved for this license as a partnership or as a LLC. And then we found out from the gaming commission that actually it was a violation, that the money should have not been transferred. Even though the contract hasn't been done, nothing has been approved, and we are not in agreement yet until the gaming is approved. So they told us that it's in violation, it has to be moved to a escrow. And immediately we moved that money to the escrow. And we didn't know that before that money comes to my account, I have to make sure that, I didn't know about the violation, and I didn't even expecting anything since I didn't have any contract with him. And when the money came in and we transferred it to LLC, after that, the gaming commissioner, they say that it was a violation.
Thank you so much for that, establishing the record. And it's my understanding that the funds from Mr. Raymond were sent initially on July 27th, 2018, went into the country store account, and then once you received your understanding that it was a violation of the regulation, it's now an escrow. When I say escrow, can you explain to me if it's in a segregated account that is under the control of the country store? What kind of escrow, if you could just explain for the record?
No, it's a escrow company that holds the fund before the business transactions, and country store has no control on that. So once, if the board approves this, then that money will come to me as the money that he has purchased 50% of the country store. And that money, if it is not approved, the money will go back to him. So we have no control over that. That's the escrow company.
Thank you so much for clarifying. And so just to be clear, the amount is 150,000 plus the 3 monthly payments of 1,000 for a total of 153,000 that's sitting in escrow right now. Is that correct?
Correct.
And sir, have you since become familiar with the regulation 8.050 that was the subject of the violation that was brought to your attention?
Yes,
Okay, and now you understand it?
I do understand, and that's why we also have enrolled into one of the conferences for, uh, it's in March, from the Gaming Control Board, that we can understand more and get more education regarding the future upcoming Gaming Control Board regulation.
Thank you, sir. And then once you've completed that, you'll just demonstrate the successful completion of the regulatory seminar so that we can have that for our files. Is that correct? Is that your understanding?
Yes,
Thank you so much. I have no further questions, and I appreciate the explanation and the clarification for record.
Do you have anything, Commissioner Cohen?
I appreciate Commissioner Brown's questioning regarding the violation, because that's a cardinal violation in the, the Gaming Control Act and the regulations. And I think that, I truly don't believe that it was an intentional violation, but it was a violation. And I appreciate the fact that on September 30th, staff notified you of the violation, and that on October 3rd, 3 days later, you took care of it, getting it into where it should have been in the first place. So with that, I feel, that I can support this application, because I don't believe there was any intent for you to skirt the regulation. It is a violation, but nevertheless, I'm looking at the intent.
yes, that is a violation, and since it wasn't intentional, we didn't know about it. But we made sure that every step that we go before we do anything, we have to make sure we refer to the Gaming Control Board and get their advice. And once they give us that advice, that we did immediately transfer the money to the escrow company.
Sir, this is Jennifer Togliatti. So I just want to clarify, as part of your explanation and detailing of what happened and how it came about, in response to Commissioner Brown, the purpose of the transfer, since there was no contract and you have to get approval in the first place, was, could you tell me that again? For visa purposes?
Yes, so what happened, Mr. Raymond, from Canada, if he comes in as a tourist visa, he cannot do any business transaction. He cannot even come in and sign any kind of paperwork. To get his visa, per his attorney's advice, that everything has to be completed on him, that he has transferred the money and there is an intent of purchasing or partnership with country store 50% of it. And that way, when immigration, they see this, that there is an intent that the money is going there, and they have done a thorough investigation for almost a year before they grant him the visa. So that money was actually, if it would have been an escrow, I didn't know anything about it, and he didn't know. The lawyer, I think, did not have enough information regarding the gaming, but we have advised that lawyer too at the beginning that without gaming approval, we cannot do this transaction. This transaction will not be done. And also his visa is also based on the condition that this deal will go through the commission, Gaming Control Board. So if it's Gaming Control Board's approves this, his visa is going to be approved and everything. But that money transfer was a mistake on all of us. We didn't have that information from the gaming that this money had to go to us escrow. So as soon as we found out, we transferred that money right away.
By then, the visa had been approved?
The visa was approved, not really. It wasn't approved because what happened is that he had to go back to Canada and reapply again. And at that time, when he reapplied again, the money was in escrow. So
I
he
see.
knew that the money was in escrow and he had to reapply it and he granted his visa recently, which he came back now here to conduct business.
So all of these questions from our regulatory agencies for something that you apparently didn't necessarily need to do in the first place, but did on an attorney's advice, an immigration attorney's advice. That's what you're saying.
Exactly. We didn't know that. Yes.
Okay. Well, I appreciate you answering those questions.
I just, thank you for being here, gentlemen. I had a quick question from Mr. Raymond. Are you now living in Carson City?
Yes, I came in October and I live in Carson City. I'm still waiting for this transaction from the gaming commission to approve the licensing in order to go ahead with the purchase of the country store. So I'm in the United States here right now. I got the visa for 5 years, and if everything goes ahead, so I can go and purchase the country store, 50% country store, and be the manager to do the duty of the country store day-to-day operation.
Well, thank you. So assuming this approval goes through today, then you're prepared to jump right into the business. Is that correct?
Well, actually, is still there is yeah, we have to go through other licensing and to complete like the transaction of the purchase. Yes,
Oh,
the
okay.
approval is essential for us to go ahead. But
Well, you had a very interesting background, and I just wanted to commend you on the hard work. I mean, it's been a long road to get to this point where you're a business owner in the United States, and I just want to congratulate you on that. I have no problem with the application otherwise.
thank you very much. Thank you all for all.
Commissioner Kika?
Thank you. So the transferring the funds into an escrow account, does that satisfy that satisfied the visa requirement, the E2 visa requirement?
Yes, it did.
Okay, thank you.
If I may just follow up briefly. So as I view the assignment and purchase agreement for the country store that's dated August 1st, 2018, I note that there's no reference in there to the condition precedent of having the Gaming Commission approve the gaming application for the restricted license. Is there a way you could provide us with an amendment to this purchase and assignment agreement so that the regulatory overlay is expressly included in the agreement so that it's memorialized for you and any subsequent assignment that might occur in connection with this transaction?
Well, when we first come to the gaming board here for application, so we knew if the application is not going through, we cannot do the transaction because this gaming license is essential for the country store. So is a something which is a big income the country store, and if this is not going through, that means like the value of country store is not the same as like purchase. So like from that moment, which is we knew the gaming has to be done in order to go ahead with the purchase. We give them all the necessary information to gaming or whatever was they asked the question, whatever the document they requested, we provide.
Okay, if you could amend or prepare an addendum or something to the purchase agreement that was signed on August 1st, 2018, to include the condition precedent for the gaming component and the commission's approval. Is that something that you're comfortable providing to us in the next 60 days to the extent this application is granted?
Yes,
Thank
that's
you.
something I believe in the original purchase agreement that we did is based on the approval of the gaming. This transaction will go through.
Okay, I don't see it. So if you can point me to the provision, I've reviewed it. It's our exhibit A, I believe, and I don't see any
And we
reference
can
to the
amend
game.
that one, yes. We can do
If
that
you would,
amendment.
please. I
Yes,
just see section 5 on page 2 that talks about the approval of a person or governmental authority. If you could just make it explicit so that it's clear, so that this contract is properly memorialized. And then just in the avoidance of doubt, in connection with the promissory note that's attached as Exhibit 2, just want to confirm that there's been no payment, of course, that's been made, no interest payments for the 3.7% for the promissory note of 100,000. That's all in hold until and unless this application is approved. Is that correct?
yes, that's correct.
Okay, I have no further questions. I really appreciate your time
Thank you so
and
much.
your explanations on the record. And I bet you're surprised to be in Nevada. I mean, you came from Afghanistan and then to France and then Canada. You've been all over, and hopefully you write a book one day. I'm sure I'll read it. It sounds like you've had a fascinating life, and thank you for appearing in front of us today.
Thank you very much for understanding. Thank you.
Thank you.
Okay, before I ask for a motion, I would also note that based upon the investigation materials, in addition to the statements um, today made by the applicants, the board, and I believe the agent who worked on this item believed or um, found that this was an unintentional violation. And so in light of that, I can support it. I assume you'll make a motion with a condition?
Yes.
Okay, at this time?
Thank you. I'm prepared to make a motion for the approval of restricted item number 2 as recommended by the Gaming Control Board and is read into the record by Madam Secretary with the condition that you shall demonstrate the successful completion of a regulatory compliance seminar for the restricted licensees, which is deemed acceptable to the Nevada Gaming Control Chair or the chair's designee within 90 days of the issuance of the state gaming license. And of course, this condition may be administratively extended by the Gaming Control Board chair or the chair's designee.
And how about
And also that an addendum or an amendment to the purchase agreement dated August 1st, 2018 be included within the next 60 days of the issuance of the state gaming license.
Sure.
So gentlemen, do you understand the motion that's been made? You'll have to go to the training and you'll, within 90 days and submit the requested amended document within 60 days. That's the motion that's before the commission at this time.
Yes, we do.
Okay.
Yes, I do.
So any discussion on the motion? All right, there being no discussion, all in favor, say aye.
Aye.
Any opposed? There are none opposed. Thank you, gentlemen. With those conditions, the motion has been approved. And we appreciate your appearances today. Thank you.
Thank you so much. Thank you so much.
Good luck.
All right, at this time, Madam Secretary, please read in restricted number 3.
Restricted number 3 is the application of Michael Van Overbeek for temporary licensure as special administrator of the estate of Betty Mumford Larson. The recommendation of the Gaming Control Board is for approval with the limitation as noted on the agenda.
Good morning, Daniel Judd of Allison McKenzie, and with me I have Michael Van Overbeek. We would be happy to answer any questions that you may have.
Good morning. I will start on this side this time. Commissioner Keycapper, do you have anything for counsel or his client?
I can use a little bit of an affirmative presentation over the application and some of the history. There's been a lot of sort of puts and takes on this one.
Counsel?
Yes, absolutely. So going back to approximately the beginning of 2021, Betty Larson was desired to change her ownership interest in the gaming license to herself, Mr. Van Overbeek, and her daughter, Cheryl Webster Larson. We submitted some applications to get those changed, and there were some complications due to kind of a misunderstanding of exactly where the ownership of the license is.
Can you speak a little bit more directly into the microphone, please?
Sorry, I apologize. So throughout the application process, we've uncovered some issues with the ownership, and we've been working with the gaming agents to complete the applications and get everything exactly lined up, which would be just fully submitted at this point. We did have a couple of mask violations, which we entered into stipulated agreement and paid all fines. Since those violations, the Timbers Casino have been enforcing mask mandates very thoroughly, and all of the employees have also entered into employment contracts where they're required to wear masks to uphold the COVID-19 guidelines. Um, on September 29th, Betty Larson passed away, and as such, we issued a notice to the Gaming Commission for death, and Mr. Van Overbeek, as Betty's husband, is named as her personal representative in her will. We are asking for him to be given a temporary license to handle the state as the special administrator and move forward and getting this kind of transferred the sole proprietorship interest into the Timbers LLC. Ultimately, I believe we have another appearance in May on this matter to hopefully approve Mr. Van Beek's and Ms. Cheryl Webster Larson's application for the restricted license ownership.
Thank you for that. I think it- part of our report from this month indicates that there was going to be an application or a request to have the gaming license surrender date administratively extended to July 30th of 2022. Has that occurred?
I believe that we have already been granted that previously.
Yes. And then all of violations and stipulation agreements have been executed and everything's closed on those matters?
Yes, sir, that is correct.
Thank you.
Thank you for being here, gentlemen. Mr. Van Overbeek, wanted to express my condolences on the passing of your wife. This application is for the temporary licensure, and I think it's pretty straightforward. I don't have any questions for you. I don't have anything further.
I too, sir, this is Jennifer Tagliati, echo the condolences. I don't have any additional questions, and unless Commissioner Cohen or Commissioner Brown have any questions?
Just a general statement. It's my understanding that the COVID compliance issues have been addressed and dealt with, and that there are no issues that you need to report to us at this time. Is that correct?
Yes, ma'am, that is correct.
Thank you so much. I just wanted to get that on the record. I have no areas of concern, and my condolences for Mrs. Larson's passing.
All right, if there's no additional comments or questions at this time, does anyone have a motion?
Yes, Chair Tagliati, I move for approval of the restricted item number 3 as recommended by the Gaming Control Board and is read into the record by Madam Secretary.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
Aye. And it appears there are none opposed. Thank you very much for your appearances today. Sir, and we appreciate your time.
Thank you guys so much. Yeah, thank you very much.
Thank you. Excuse me. Let's see here, so. Madam Secretary, please read in restricted number 4.
Restricted number 4 is the application of Rob Inc. doing business as El Adobe Cafe for restricted gaming license, and the applications of Raul Burman and Javier Burman for licensure as an officer, director, and shareholder. The recommendation of the Gaming Control Board is for approval with the conditions as noted on the agenda.
Good morning, Madam
Morning.
Chairwoman, Commissioners, and Madam Secretary. For the record, Adriana Freilich, and I'm here on behalf of the applicants. I have with me Javier Burman and Raul Burman. on behalf of El Adobe Cafe. And you may have read in your materials, Mr. Berumen has had an extraordinary life. He was one of 13 children in his family. He came to the United States as a young man, worked in some of Reno's best restaurants before he opened up his own restaurant, El Adobe Cafe, in Reno. It's been open about 22 years. And now he and his son Javier are about to embark in a new venture, adding gaming to their establishment. But I'll let them tell you all about that and answer any questions that you may have.
Thank you. Who's going to address us first?
Hi, my name is Raul Berumen. I am from Jalisco, Mexico, and 77 to Nevada. And I've been working in restaurants around Carson City and Reno. And we decided to open our store 2000, and we're still around.
My name is Javier Berumen. This is obviously my father. I'm a first generation Nevadan, first generation on my father's side from Mexico. Lived in Reno majority of my life, and took over running the business with my father in 2006 and trying to expand, grow as the city has grown as well.
Okay, we would appreciate it very much as we continue this proceeding if you could just get a little closer to the microphone. Unfortunately, some words are cutting out or just are lower volume, so we appreciate you speaking up a little bit and getting closer to the microphone. I appreciate the introductions and the background that you gave us. This time, I'm going to start with Commissioner Piekapper, if he has anything.
I have no particular concerns about this application, Madam Chair. I'll note that Mr. Berman is, their application state they work 7 days a week, 13, 14 hours a day or more, and it's a testament to their work ethic and the success of their establishment. Adobe is a very popular spot up in Reno, and I'm sure that this expansion will serve them well. That's all I've got.
Commissioner Solis Rainey.
I also didn't have any questions. The application was pretty straightforward, and it looks like, your hard work is paying off, and I'm glad you're having the opportunity to expand and support the application.
Thank you. I share my fellow commissioners' comments regarding, the work ethics as shown in this application. I just wanted to confirm one thing because it is approximately 10 months ago. The participation agreement with Century Gaming is still in full force and effect. You haven't entered into a new arrangement with anyone?
No, we're still a Century.
Very good. Thank you very much.
Just some comments from me. I think it's commendable and it makes me so happy to see the family business growing into the next generation. It warms my heart. I've heard nothing but wonderful things, and I hope to check out the restaurant one of these days. Could somebody just give me a quick summary about the construction permits and the new upgrades, just briefly for the record, so I can see where you are on that?
Yes, we are actually, we're right there with our permits. We're going through Tom Hall right now to get a backflow issue taken care of, and then they are going to be freed up. And as soon as that happens, we'll start construction within the next few weeks.
And when is your anticipated completion of construction?
We're hoping by the end of March, beginning of April.
Okay, well, thank you. Good luck. Happy to see that you're expanding and moving forward and continuing the restaurant culture up in Reno, and hope to come visit one day. I have no areas of concern. Thank you.
Okay, thank you. Any other questions or comments? All right, there being no additional questions or comments at this time, do you have a motion?
I have a motion. I would move for approval of restricted agenda item number 4 is read into the record by Madam Secretary and is recommended by the Gaming Control Board.
Any discussion on the motion? There being none, all in favor, say aye.
Aye.
All right, gentlemen, unanimously approved. Thank you for your, and lady, council. Thank you for your appearances today and good luck.
Thank you.
Thank
Thank
you.
you very much.
Thank you.
Okay, Madam Secretary, could you please read in restricted number 5?
Restricted number 5 is the application of Dolan Consortium LLC doing business as Shanty Dolan's for restricted gaming license, and the applications of Shane Dolan, Nate Dolan, and Breck Dolan for licensure as a member and manager. Recommendation of the Gaming Control Board is for approval.
I'm sorry, I'm just inquiring as to some of the noise. Okay,
Good morning, Madam Chair, members of the commission, Madam Secretary Jeff Donato here with Argentum. Before you today is the application for the applicants to hold a restricted gaming license for the location. We did give some information, background information about the applicants at the board meeting. If you would like, I could have them give some information about themselves again, if that's
Please.
okay with you.
if you would, please.
Shane, if you want to go ahead and start.
Yeah, thank you for having us. We're happy to be here. All three of us were born and raised in Reno, Nevada. Our father played football at UNR, and we went to Reno High School, and it's been a lifelong dream for us to work together as brothers. We've worked on a couple other operations together, but we've never really gotten together to take the next step. And we all have 2 kids each under 5. And COVID had did a few numbers on us with our other businesses, and we all decided to move back to Reno. Nate was already living here. And at that point, the opportunity came up for us to get this license started, excuse me there. And we were really excited about it. So it's a family operation and it's a family business, and we aim to make a family gathering spot with this bar for Reno and the community, and give something back to the place that we were born and raised and love being here. So thanks for having us. And if you have any other questions, we'd love to answer them.
Hello, my name is Breck Dolan for the record. And currently I moved back here about a year ago in October, and happy to be working with my brothers again. I have been getting my master's degree in psychology, East-West psychology from California Institute of Integral Studies. And I'm now currently finishing up my PhD. So I'm working on my dissertation for my PhD. And this opportunity came to fruition, and it's always been a lifelong dream to bring our families together. So really happy to have the opportunity to work with Shane and Nate. So thank you.
Hello, Nate Dolan. I was already currently living in Reno, practicing a real estate profession. And I recently, in May, took over our dad's business as a farmer's insurance agent. So when they both moved back, we had this opportunity, and I couldn't have thought of 2 better partners, and wanted to take this leap with them. So thank you.
Thank you. At this time, I will start to my left. Commissioner Brown.
Well, I want to welcome the Dolan brothers. You are very lucky that you get to work together on a venture. I have 3 sisters, and I think that would be so cool. And I commend you for doing that and getting to work together. And I hope they have lots of success in the future. Could you maybe explain between Shane, Nate, and Breck the different roles that you'll be taking in connection with this new venture?
Sure. So I'm the majority shareholder in the operations, and will be heading up the day-to-day operations, doing all of the bar managing and hiring and those kind of, day-to-day experiences down at the bar every day, checking in and making sure people are arriving and going to their shifts, and making sure that we're following all the rules and regulations that the gaming board set forth. We've already sat through the seminar, and are happy to enforce that. We always, growing up in Reno, understanding how important it is to have the 21 and up rule, and being kind of shooed away from anything at the grocery store when my mom was playing the slots or something like that. So just me being the main operations manager and overseer, Nate would probably is going to be heading up a lot of the administration stuff, the paperwork and follow up. And Breck is definitely our PR person and the voice and the face of getting people in there. He's really good with marketing and making sure that we have a steady flow of customers coming through. He's definitely our PR and public relations person out in the community.
Thank you for that. And I know that when I watched the presentation in front of the board, there was a music and art world juxtaposition where you have some involvement in art. Will there be any art or music that will be featured at your location?
Definitely we will integrate that if possible. Currently, right now, we don't have the cabaret license, so we'll have to work on possibly extending that if so granted down the line. Right now, we would definitely have music, and you know, art is a specialty, so having displays of art and possibly some performance or some kind of people coming through. Most of it is just personality and customer relations, and something we've really been successful with is being good customer service, making sure that people are happy and taking care of our customers, because that's how you make money.
Well, thank you so much. I wish you nothing but success and luck, and I think you're off to an excellent start. I have no further questions. Thank you.
I just had a quick question with respect to food. I watched your presentation before the board, and I believe your plan was to maybe incorporate food trucks into your operations. How is that going to work as far as hours? Is this a 24-hour bar, I assume? Or
No,
no?
currently our time frame is to close at midnight.
Okay.
Yeah.
Okay. So is your intent to have kind of food trucks there for lunch hour and then the dinner hour? And
We would test market first, have food trucks there when we know it's going to be busy, so that they're making money too. The last thing we'd want to do is have somebody sitting there all day and not making any money. And so trying to coordinate with when our busy hours are. But yes, most likely lunch rush and then a dinner rush. And if they can stay through the lunch and dinner, maybe a happy hour kind of thing, that would be great too. So it's kind of just coordinating with the food truck industry and seeing how we can best serve everybody involved.
okay, great. Thank you. I'm very excited to see the three of you working together. I'm sure your parents are thrilled. I know I would be thrilled to have children in one city and working together. I mean, that's a dream of probably a lot of mothers. But seeing your different personalities too is exciting, because I think you're going to really each bring something different to the business. And I wish you nothing but the best with that. I don't have any further questions.
Thank you.
Thank you, Madam Chair. Certainly appreciate the emergence of another family business. It's always great. And the family business extends a little further, right? It's your uncle who's the landlord. Is that accurate?
Currently, he is the landlord, yes, and our uncle from Reno Toyota, yeah, Tom Dolan.
Obviously, he's a successful businessman in his own right, and will be a good sounding board. But he's not on the application, and he won't have any operating control over the business itself, right? He's serving just as landlord.
Correct.
Excellent. That's all I have. Thank you, Madam Chair.
All right, and in listening to the descriptions of what you each intend to do for the property and as part of your business, how much of that is going to for actual on-site, day-to-day, hour-to-hour? Obviously, you're going to be in a position to be on property a lot, but what about your brothers?
Um, I plan on being there a good amount of time also, at least 20 hours a week. Um, my two professions allow me to work remotely, and being on site and available is something that I plan to do and be there for this business.
Rec here, and I struggle with the case of FOMO. It's called fear of missing out. So I definitely will be there all the time as well. So it minimum of 20 hours.
Thank you for that. I appreciate it. I don't have any additional questions.
I may, Chair.
Yes.
How is the remodeling and that side of it going? Are we still on track for the February opening?
We're looking pretty good. I was just at the health department yesterday filling out some of the application forms and paying the permit fees. And bearing that, you know, some of these, we have a couple of little hangups with just supply chain and the copper top for the bar that's coming in and the wainscot that's going around the side. Most of what we've done has been aesthetic, cosmetic upgrades. And so getting all of our finances in line and making sure that all of that is on board, then it looks like we should be shooting for the end of February. We'd love to have it be 2/22/22, just because I think the number is a lucky number. So that's hopefully the date. And yeah, we're really pushing for it. There's a couple people down there right now working and checking in with us during this meeting. So things are moving in the right direction.
Thank you so much. We wish you all the best, and I hope you make the 2/22 opening date. Sounds like a good marketing tactic as well.
Anything else? All right. At this time, do you have a motion?
Yes, Madam Chair, I would move that we approve restricted item number 5 as recommended by the Gaming Control Board and read into the record by Madam Secretary.
All right. Any discussion on the motion? There being none, all in favor say aye.
Aye.
Aye. And it appears there are none opposed. Thank you. Thank you, gentlemen, for your appearance today.
Thank you. And we also have to
Thank you
thank
very
Agent
much.
Finlayson for all her hard work during the application process.
Thank you for that. All right.
Thank you, and thank you, Jeff Donato.
Thank you.
All right. We are moving on now to restricted item number 6.
Restricted number 6 is the application of Maharashtra Inc. for licensure to receive a percentage of revenue from Sartini Gaming LLC, doing business at 7-Eleven store number 22629, and the application of Ramon Aurora and licensure as sole officer, director, and shareholder. The recommendation of the Gaming Control Board is for approval.
Council, if you could state your appearance again for this matter.
Good morning, Madam Chair, members of the commission, Madam Secretary Jeff Donato here with Argentum, here on behalf of the applicant, and joining me today in Carson City is the applicant, Mr. Aurora. Before you today is the application for the applicant to share in gaming revenue. Currently, he is on space lease, and if approved, that space lease agreement will convert to a participation, and he will start sharing in gaming revenue at that time. With your permission, I'd like to have the applicant give some information about himself, if that's
Please.
okay.
Thank you.
Mr. Aurora, if you want to go ahead and give some information about yourself.
Thank you. Good morning. My name is Raman Arora. I have done a Bachelor of Commerce, also postgraduate diploma in computer science and application. That is helping me in my business with changing technology. I've been with 7-Eleven since 2008, and it's been very successful business for me. May 2018, I acquired this business in Carson City, and I'm very happy with it. A lot of hard work. Me and my wife, we are working there. She is supporting me. I'm very thankful to her. Also, I have support from 7-Eleven. So everything is going well. I want to convert leasing to restricted gaming. That's all. Thank you.
Okay, thank you.
That here, we're here to answer any questions you may have.
Okay, thank you very much. Do I have any questions on this side? No? Any comments or questions? Commissioner Brown?
Thank you so much for your appearance today. How are you?
I'm fine. Thank you.
Wonderful. If you could just give me some brief background and explanation regarding the arrest for domestic violence, and the accusations that were made by your neighbor. I understand that it was not prosecuted by the DA's office, but I'm trying to understand what transpired. And if you could just provide me some information for the record.
Sure. Um, I think that happened in November 2005. That was a small argument over the laptop, but it changed my whole life. Later, based on that, me and my ex, we got divorced, but I'm happily married now since 2016. My wife is here to support me also. Um, yeah, I mean, there was no charges, no nothing, but my neighbor called because she was having problems with her husband and she thought we are going through same situation. But I was released same day and no charges, no fines, no penalties.
I'm just not understanding what happened that resulted in the police being called. If you could just give me a little detail for the record. And if you
Sure.
could come closer to the microphone, I'm having trouble hearing you, sir. Thank
Okay,
you.
sorry about that.
No, no problem.
I used to work with New York Life Insurance as a financial advisor. So I was using laptop, I believe. My ex came from her work and she started using laptop when I was getting ready to go for a meeting. So in uh, in the laptop there was a software that we have to use for the client, and I prepared everything. So she came and she closed everything and started using it. So there was a small argument, and then I mean, only thing I remember is she went to the neighbor. She said she's gonna leave, and she went to the neighbor, and neighbor called the cops uh, after hearing our argument. And yeah, um, my ex went to the cops, police department, and I was released same day. She was the one requested to release me.
Okay, she bailed you out, right?
Yes, ma'am.
Okay, and was there any physical altercation between the two of you
No,
at that
ma'am.
incident? Okay, and you haven't had any other issues or incidents with domestic violence or anything else that's been alleged against you, correct?
Yes.
Okay, thank you so much for answering those questions so candidly. And you saved by the bell, your time is up. Thank you, apologies.
Okay, thank you, sir, for answering our questions. Is there any other questions or comments by the commission? All right, there being none, do we have a motion?
I'm prepared to make a motion in support of the restricted item number 6 as recommended by the Gaming Control Board and as read into the record by Madam Secretary.
Right, any discussion on the motion? There being none, all in favor of the motion, say aye.
Aye.
Aye. There are none opposed. Thank you very much.
Appreciate that. Want to thank Agent Finlinson again for all her hard work during the investigation.
Thank you. Sir, thank you for your appearance from Carson City, and congratulations.
Thank you so much.
Thank you. At this time, Madam Secretary, please read into the record restricted number 14.
Restricted number 14 are the applications of Apollo Gaming Corp. Doing business as Nevada Gaming Corp. Doing business at the Lodge at Stephanie and the Lodge Lounge for restricted gaming licenses. The recommendation of the Gaming Control Board is for approval.
Good morning, Chair Tagliati, Commissioners, Madam Secretary. I'm Greg Gemignani from the law firm of Dickinson Wright. Really filling in for Jeff Silver on behalf of the applicant for restricted gaming license at Caption locations. As you know, the applicant operates several other restricted locations as an expanded gaming licensee. At the board meeting, there was some question regarding a matter with the Office of the Labor Commission, specifically the settlement amount that was agreed to with the Office of the Labor Commission and the difference between the wages at issue, interest, and the ultimate dollar amount. That difference is $1,620. I did call the Labor Commission to identify what that amount was for. The Labor Commission wouldn't talk to me because I wasn't on the record and it was a closed matter. So I talked to the attorney, Rick Ross Kelly, that was on the record and that did negotiate that settlement. And according to Mr. Ross Kelly, that amount is a discretionary amount that the Labor Commissioner can assess as an administrative fee on settlements. So according to him, that amount was discretionary. It was agreed to, but there was no admission of wrongdoing, no finding of any violation of labor laws or regulations. And his goal was to settle that matter amicably and quickly. And they thought that settlement was fair. And so they executed the settlement. And that's about as much information as I could get on the settlement amount. But at this time, I'm also pleased to introduce you to Stuart Apollo, the principal of Apollo Coin, and Renee Holmes, the director of finance. And I'll have them introduce themselves as well.
Good evening, well, afternoon, Madam Chair and members. I'm Stuart Apollo, president of Apollo Coin.
My name is Renee Holmes, Director of Finance of Apollo Coin Corp. and Roger Stephanie LLC.
I think my mic is off. Just so that we can clarify that conversation you detailed with the council on that matter. So I'm understanding that this was a discretionary amount. They categorizing it as a, like an reimbursement for investigation fees or a fine, or because you used the word fee, so I'm just curious.
Yes, Greg Gimignani for the record. Yeah, when I talked to the Rick Ross Kelly, he mentioned that it was an administrative fee. It may be identified as a penalty or a fine, but the Labor Commission has a discretionary amount that they can assess between nothing and $5,000. And he thought that the $1,620 amount was fair in order to resolve this amicably and quickly. And his view was that he thought it represented sort of the time they had put in on the matter. So
Okay. Thank you. So I think I'll start with Commissioner Keycapper, if you have anything.
So just for the record, this matter is now settled, right, with that agreement with the Labor Commissioner.
yes, on November 21st, the Labor Commissioner sent a letter saying that the matter was closed and settled.
Does that preclude the employee from any civil litigation on the matter?
When I talked to attorney Ross Kelly, he said that it would preclude certain claims. I'm not a labor attorney.
Nor am I.
I did have a introduction to labor course in law school a long time ago with the former solicitor for the Department of Labor during the Carter years, but it's a long time ago. But he did say that certain claims would be precluded going forward.
I appreciate that. Thank you.
Thank you.
I don't have any further questions. Thank you.
So as part of the discussion before the board, and I think I read in materials, there's been some policy and procedure change within the company to advise employees that they can be disciplined. And does that, for a violation of your policies and procedures, presumably about money handling, right?
Yes.
Does that include advising them that that they could be required to pay back losses?
It's, this is Renee Holmes. So the in the wake of Mr. Parker's situation, we wanted to clarify stuff so that everyone is, for the lack of a better term, on the same page. So we updated the existing workplace violence prevention program, which also includes the cash handling process and the robbery, during the robbery and such. So we revised this specifically to notify employees that there's no repayment obligation by employees. However, violation of the policy, not following policy, may lead to the disciplinary actions.
Okay, so those disciplinary actions though wouldn't involve restitution or some kind of,
Whatsoever.
okay, okay, that was my understanding. I just wanted to make that clear for the record. So even though this was resolved and with a satisfactory outcome for you before that other entity, governmental entity, um, there wouldn't be a scenario where that could happen again, I guess is the gist of what I'm trying to establish here, based upon your change in
Yes.
approach to these matters. Okay,
100%.
okay, thank you. I have no other questions. Thank you for your appearance today. Do you have anything?
Just one question. Regarding Mr. Park. Now, in our materials, it talked about that there was a settlement and the check was tendered to the board, but Park has disappeared. Is that accurate and still remains accurate?
Well, with our limited knowledge, because in this day and age, we can try to attempt to look for somebody's whereabouts through Facebook and such, right? So we know that he's not in state of Nevada. He moved back to Boston, I believe, but we haven't had any contact with him or successful in reaching out to him. And as of today, the check that we tenured to Labor Commissioner Board, which in return they sent it to Mr. Parker, still has not been tendered. So we have no idea why that is.
Fair enough. Thank you.
I'm just having a little bit of trouble from a very basic contractual level. Mr. Parker is a party to the settlement agreement, but he hasn't signed off. And has he participated in the process at all with the Office of the Labor Commission?
Again, Greg Gibboniani for the record. My understanding from talking to the labor attorney is that he hasn't, that the Labor Commission was unsuccessful at getting him to participate at all. But the matter was filed by him through the Labor Commission. And so the applicant dealt with the Labor Commission through their counsel and resolved the matter, at least with the Labor Commission. But where Mr. Parker is and why he's not responding to them or anyone else for that matter, we just don't know.
Understood. And it's my understanding that the matter has been closed by the Labor Commission, but notwithstanding that, the party that needs to sign off, Mr. Parker, has not actually executed the settlement document. And I'm so concerned that there's no actual settlement with Mr. Parker because he hasn't signed off. So to say it's closed is one thing, but I don't know that I can say out for the record that it's actually been settled.
Again, Greg Gibboniani for the record. When I talked to the labor attorneys, as far as we know, that's the only matter between the applicant and Mr. Parker. It was before the Labor Commissioner's office, and as far as the Labor Commissioner's office stated to us, it's as far as we can go. We've complied with everything they've asked us to comply with, and we certainly don't have any control over Mr. Parker. And I understand that not having him sign the agreement with the Labor Commission is a concern, but that's something we just don't have any control over.
It's not about the control and your part at all. I think you've done everything that you're supposed to do. But if the check is never cashed, and there's really no consideration for the settlement. So it's just going to very basic contract principles. But if the matter is closed, there's really nothing more you can do. I just don't know if it's actually settled without money exchanging hands and execution and consent from the party that's been allegedly aggrieved, Mr. Parker.
Again, Greg Gibboniani for the record. I don't know either. I'm not a labor attorney, but I know that when I talked to the labor attorney, he did say that by us signing by the applicant signing the settlement agreement and having the Labor Commission close the matter, that certain claims of the former employee were going to be barred going forward. So,
okay.
If I may add a little bit to that, I believe once we signed the settlement agreement, or at least the settlement agreement was available, my understanding through our labor attorney was the labor commissioner via email or something reached out to me, Edward Parker, notifying him of the certain timeline deadline for him to reach back to a labor commissioner. So it was my understanding that he didn't do that part. So in the beginning of the filing the claims, obviously he wasn't in talk. He was in communication with the Labor Commissioner Board. But once he was notified of the settlement with the specific timeline, he did not comply with this. So after that point, when we reached out to our labor attorney, at that point, a labor commissioner's board office has the authority to close the matter. So
Okay.
that's how far we got.
Has anyone sent Mr. Parker a text message attaching the actual settlement agreement? I personally have had an issue with service on a different case, completely unrelated. I've actually sent text messages and forwarded PDF documents that were filed by the court. Has anybody on your side endeavored to do that? Because I see a history of text messaging when he resigned.
Yeah, but then we after Edward Parker filed the claim, when we were notified of the claim, and then going through the settlement talk with our labor attorney, I believe we stay away from contacting him directly. So no, we have not done that internally. I don't know. I'm not sure 100% what type of communication channel the labor commissioner notified Mr. Parker of the deadline, whether it was via text or via email. I cannot answer that today.
Is it possible for somebody internally, even if it's through council, to actually send a text message attaching the settlement agreement to Mr. Parker so that we know that he's actually received it?
Again, Greg Tremagliani for the record. I can check with Labor Council on that.
Yeah, if you can get the approval so that you're not violating any ethical rules to the extent he's represented by counsel, I just want that for your record so that it's clear that you've endeavored to give him proper notice, that there aren't any due process issues. I understand he started the process. He didn't seem like he finished it, and that's not on you, that's on him. But just so you know that he physically has possession and that the check is available for him to cash, I think if you could just text him that, a lot of people do respond to text messages. I would feel comfortable if you're willing to do that.
Again, Greg Tremagliani for the record. I'll talk to Mr. Ross Kelly about that because I certainly don't want to circumvent the process that the Labor Commission is involved in or do something that would offend
If it's
the Labor
permissible,
Commission.
please do so. Thank you. And then for the repayment agreement that was dated December 4th, 2020, who drafted that agreement? Because I see it appears to be on the lodge letterhead.
It's a simple standard kind of deduction. And for instance, if people um, wants to get I don't like insurances and stuff like that. So it's not some form that we specifically created for Mr. Parker.
It's a pre-existing document.
Pre-existing, just a deduction form that, we have it on file. We just put his name on it.
Okay, and can you tell me who was present at the time Mr. Parker voluntarily said he would repay the funds that were robbed? Was it more than one person present? Do you have any witnesses?
Yes, there was. And the agent, we testified. We had our director of operations there, and I was present at that meeting. And the demanding any repayment never issued, was never even approached. And I think, as I explained to the board, that our concern was, one, his welfare after the robbery. And number two, I personally explained to him that he didn't follow procedures which were put in place for his safety, patron safety, co-worker safety. And that was the discussion. And during that discussion, we showed him the tapes and how negligent he was with that money closing process. And he was so apologetic that he insisted. I didn't want to take it, but he went out, and until this whole thing came, to my knowledge, I didn't even know what amount, what repayment schedule he scheduled until this hit, the newspapers.
There was never a threat on your side that made clear to him, if you don't pay this, you'll be fired. Is that correct?
Yes.
All right. And was Mr. Parker ever the subject of any disciplinary actions after the robbery for not following the procedures for handling the cash properly?
After the robbery?
Yes.
What's in his file, I'm not sure, but he wasn't a role model employee. You know, I'm not here to
But was he
discuss.
disciplined in any way?
I believe there was a write-up because
Okay.
it was the third robbery. It was the time of the year, usually in December for industry like us. So it was the third robbery that we experienced within the span of month or so. So following the precedence, there was a write-up.
But the first robbery involving Mr. Parker, correct?
Correct.
All right.
Or for the location.
Understood. And for the Lodge Tavern Group's workplace violence prevention policies and procedures that were promulgated, did something exist prior to that that had the specific requirements for how to handle cash, how much to put in the safe,
Correct.
how not to count it on the counter in front of everyone?
Correct.
And did he sign those policies and
No,
procedures?
he did not.
Okay, and why is that?
It could have been administrative, the hiccups, because we rely on our field managers to go out and collect the signatures.
And have you
So-
verified if all the signatures based on the newly
But
promulgated?
newly one, we make sure that we log it. We make sure that every single copy went out of the corporate office gets returned with the signature.
Okay, and so under section 2 point, subsection 2.5 of the new policies, where it's very clear, you say that you will not be asked to repay for the financial loss as a result of any robbery. That is brand new language that was included as a result of the Parker situation. Is that correct?
Correct.
Okay,
Not because we've asked our employees to repay before.
but just to make it clear.
Just to
Yes.
make it
No,
clear.
I understand.
Yes.
All right, well, thank you so much for, was there an insurance policy that was claimed in connection with this robbery?
It wasn't, and also it was below the deductible.
Okay, all right. And then last question, have any of the building permits with the city of Henderson been issued to allow for the remodeling to be completed?
Yes.
Okay, and so where are you on the remodeling process?
Well, I believe tomorrow we will start on demoing and, we got our longer lead items in. And so we're hopeful, by the end of May, to be open.
Barring any supply chain issues.
Yeah.
that
Of course,
we
that's
deal
an
with,
issue.
Which is a major issue.
And after the Parker incidents with the robberies, have there been any other robberies that have occurred?
Not to our knowledge. It's usually very seasonal for the industry like us, but
Okay.
then obviously more awareness and then things that we can help our employees to feel safe at their workplace has been implemented by the management. For example, we are investing on new technology when it comes to gaming safe dispensing money, which kind of limits the need for bartenders to keep so much money on a just traditional like a little safe.
Okay.
So if it gets dispensed by the really secure safe, then they don't have to have so much money on site.
Okay, and I
They have a
can,
control over.
yeah, it was like a $500 limit.
Yeah, and then all the denominations. So we are investing significant amount of capital in outfitting all of our existing locations on that. So that goes along with the upgraded surveillance system, and also the certain locations, magnetic lock on the front door. However, that mechanism, you still have to rely on our judgment of our employees to
Of
let
course.
who to let in. But we are doing everything in our power, in our control to make sure that, our employees feel safer.
I appreciate the efforts that you've undertaken with the new policies and procedures. I think that you pivoted very quickly to make sure that these issues are covered because you don't want to have the bad press that you had. I think I remember reading about it in the
Oh, yeah,
newspaper.
it was horrendous.
And it's nice now that you're able to clear the record and to explain to the extent anybody's interested exactly what transpired. So thank you for being so forthcoming. I have no issues at all.
Thank you so much.
Thank you. Mhm.
Yes, Madam Chair, I would move that we approve restricted item 14 as recommended by the Gaming Control Board to the record by Madam Secretary.
Aye.
Thank you.
Thank you.
Thank you very much.
And we would also like to thank Agent Blinson. I mean, she's been wonderful guiding us through the whole steps. Thank you.
Thank you.
Okay, we're going to reconvene at this time. And I'm going to ask Madam Secretary to read the next agenda item, please.
The next agenda item for your consideration are proposed amendments to Nevada Gaming Commission Regulation 5.225 as noted on the agenda.
Okay, I know we have at least one Zoom appearance. Is that person on? Or at least, there we go. Okay, so
That is Mike Sumps from the Attorney General's office.
Yes.
He is available for any questions you may have.
okay, and so who do we have attending on this item, if anyone? Have a list here of the people we anticipated would be here.
Sir?
Sure. Okay, I'm sorry, just one second. I think David. My understanding,
Mr. Van Prickle is now on via Zoom. He just needs to speak so that we can see him.
okay.
She's female. Barry is.
Oh, sorry. My apologies.
Okay, and it's my understanding, as far as Senior Dag Somps, who is going to present on this item, is going to be.
Yep, Madam Chair, this is Mike Somps with the Attorney General's office, and I anticipate that Sightline will be making a presentation for you today.
Thank you. One second. Okay, so at this time, go ahead and state your appearances, please.
Madam Chairman, Chairwoman, Commissioners, Madam Secretary, my name is Omar Sattar. I'm one of the founders and the co-CEO of Sightline, Nevada licensee here. And Ms. Carlton and Mr. Michaels and our team very graciously prepared detailed remarks for me. But before that, I wanted to share something a little bit more personal for you, so forgive me, Jennifer. I moved to Nevada in 2005 and as a 26-year-old to work for a company, what was then called Global Cash Access. Today, the company is called Every, as you know. It used to be a privately owned company. And the reason for me to move to Nevada in 2005, or a very big part of the reason of the job that I have, at that point, Global Cash Access had a partnership with IGT, with International Game Technology, to create and deploy cashless technology for Nevada casinos and casinos throughout the country. And so I moved here 17 years ago for the specific purpose of why we stand here today right now. And I have spent the better part of my the last 17 years both learning and deeply immersed in the business of payments and gaming. And we finally believe that we are on the cusp of deploying modern payment technologies across casinos, not just in Nevada, but throughout the country. And firstly, we'd love to congratulate Boyd Gaming and both Resorts World for being early pioneers on the adoption of the technology in Nevada, in other jurisdictions, as well as for Resorts World on the Las Vegas Strip. They both knew when they adopted the technology that it had many failings in it, and not the least of which is the one that we're hoping that can get corrected after the Commission's consideration of this reg change, and that is remote ID registration. And historically, in the state of Nevada, a patron, before a cashless transaction could be conducted, had to present a physical ID to a member of a casino staff, whether it's at a cage or a slot machine or what have you. And if this reg change is approved and the appropriate technologies are deployed, that ID verification would now be entirely done both by the documented or undocumented in an entirely digital manner. And so we're very excited. I personally am very excited, like I said, and we've been waiting on this for the last 17 years. We think we are on the cusp of the adoption of the technology. So I personally am very excited. I'll turn it over to Ms. Carlton, but I'm available to talk about any parts of the technology, the pain points that have been seen by the trials that have been done by both Boyd and Resorts World in Nevada, and how we see the future evolving for Nevada licensees over the coming months and years post-adoption of this new technology. Ms. Carlton?
Thank you, Omar. Good afternoon, members of the Commission, Secretary Bell. My name is Jennifer Carlton. I'm the Chief Legal Officer for Sightline Payments. Also joining us from Sightline today, we have Jonathan Michaels, our Vice President of Government Affairs. We have Joe Papiano. He's our co-CEO at Sightline Payments. Felicia Gasson, she's our Chief of Staff. And Shannon Nadeau just joined us as our Head of Compliance and Licensing, and used to work for the board, so she might be a familiar face or name. On the phone, we also have Barry Van Breckel. She is outside counsel, payments counsel with the law firm of Oric. And she specifically had, we had asked her to participate in case there were any questions related to the FinCEN guidance. That was the subject of some discussion at one of the first workshops that we had related to this petition. So as you're all aware, Sightline Payments filed a petition to amend Regulation 5.225, specifically to allow for digital validation of a player's wagering account. And this would be for on-premise casino wagering. So we're not talking about amending Regulation 5A for interactive. As you all know, that's already allowed for an individual who's participating in interactive wagering to verify their identity remotely. We're also not speaking about any amendments to Regulation 22, which would affect sports wagering. This is specifically for in-casino wagering, and it's limited to that effect. So the request, the petition that was filed is to allow for, as Omar mentioned, having an individual be able to establish an account and verify their identity remotely, rather than having to show their identity, their identification card, their driver's license, or their passport to a person within the casino in order to be able to finalize the establishment of a wagering account. During the workshop, the board made some amendments to our proposed language, and specifically allowing for the utilization, first of all, of what's referred to as documentary evidence. That's the portion of the provision that provides for a government-issued picture identification credential. So that would be the documentary evidence that would be required, coupled with a verification method that enables the licensee to form a reasonable belief that it knows the true identity of the patron. That is what would be referred to as the non-documentary evidence. So these two work together. So it's almost like a two-step verification process that you're all used to with your computer and then having to get a text message on your phone. So there's a documentary piece and a non-documentary piece for the verification of the individual's identity. That's the language that was proposed by the board and that we support here today. In conclusion, I'd also like to thank the members of the staff that assisted us, specifically, of course, Board Member Casaros was very helpful with us working through the language. Of course, Deputy Attorney General Somps, who's appearing remotely from Reno, was very instrumental in working through this language with us and getting us to where we are today. We really appreciate all the efforts of the staff in helping us get here. Thank you.
Thank you. As far as questions, comments at this time?
Thank you, Madam Chair. Mr. Khan, you referenced some pitfalls in the rollout. Are any of those pitfalls related to actual ID verification, or is it sort of more process information?
It's a good question, Commissioner. It's pitfalls related to some to do with ID verification, but not so much verification. It's the time that it takes for a patron to enroll. So when we look at payment ecosystems, and there are many that you use, and when we use payment ecosystems, even a debit card in your pocket is a payment ecosystem. A credit card, you might be someone who uses Apple Pay, Android Pay, maybe you use Zelle, which is available to you from your bank. You might use Venmo, you might use PayPal. There's four key things that we find that are important for a consumer in order to adopt it into a payment ecosystem. The first and foremost is security of money. No one ever puts their money someplace where they feel it is not safe and secure. Whether personally we like banks or we don't, but for the most part, we keep our money in banks because we believe that the money is safe and secure. But The second piece is we want easy access to our money. At the end of the day, we want to eat and drink and shop and dine and do the things that we want to do as quickly and as easily as possible with our money. The third, increasingly so with consumers, consumers expect to be rewarded with loyalty for all the things that they like to do. And that could be gaming activity, it could be non-gaming activity. And so when they spend their money, they want to be rewarded for that. And the fourth piece, and that I think really gets to the heart of the question that you're asking, is cost of access. And cost of access doesn't necessarily mean how much are you paying to access your money, but it actually talks about how quickly you can access your money. So, how many steps does it go through in order for you to access your money? And what we found, despite the absolute best efforts of our partners at Aristocrat at Boyd and Konami at Resorts World and the operating teams on the ground as well, and the process was very cumbersome, especially unfortunately at Resorts World. Kind of the golden metric that we look at as an industry and are looking at as an industry and trying to replicate from Silicon Valley, and what we're now calling time to play of 3 minutes. And so from the time a patron decides that they would like to participate in an ecosystem, so that means, and to the time they're actually playing should be 3 minutes or less. That we believe should be the golden metric that will lead to large scale user adoption, and which means someone's going to download a mobile app, they're going to create an account, they're going to get verified, they're going to put money in it, they're going to walk up to a slot machine or a table game, they're going to swipe their phone, and they're going to be validated, and they're going to start playing. And at Resorts World, because of the ID enrollment issues or the ID verification issues, the absolute best case scenarios we saw were 7 minutes. So it was at least twice as bad. But in the bad case scenarios, it was more like 2 hours. So people were unfortunately waiting in lines and in order to get enrolled, and we were very excited, both Nevada residents and tourists alike, about participating in the ecosystem. And so making this reg change, we believe, will have a significant impact in the existing licensees that have deployed the product and other Nevada licensees. And the reality is Nevada is the intellectual capital of not just America, of the world, for everything that happens in gaming. And so we believe what is built and deployed here gets replicated really all over the country.
If this regulation is approved, what is sort of your timeline for deployment of this within your existing sort of licensees that are operating?
So we are hoping as soon as March. So the technologies that we're using, not just us, and obviously many others will benefit from this, whoever is providing cashless technologies in the state of Nevada. They're very well-known third-party providers, big companies like LexisNexis that provide the tools in order to verify IDs in real time. Those same tools are used by a number of the Nevada licensees today for their AML and their KYC programs, but there's specific technology sets. So we are hoping as soon as March, you are going to see upgraded products in the market, and we're excited about that.
And I think from Mr. Somps, for Deputy Attorney General Somps, under 5A, this is obviously allowed, right? And have there been any issues from our perspective in use of this process under 5A?
Commissioner, I'm not aware of any issues. I would defer to the board or perhaps Jim Barbie is there, but I'm not aware of any issues.
Mr. Katsaros?
Certainly, I wouldn't have the detail other than to say, no, we've not had any concerns from that standpoint. This has been in place for approximately 10 years under Reg 5A, give or take, if I'm getting the timeline right. It's also been deployed in other markets as well. Now, they did have some hiccups early on in some other markets. The way we've crafted this and the way we would regulate it, we of course would draw upon what their experience has been, and we wouldn't expect to have any issues on this regulatory change neither, because it would essentially mirror what we have in 5A.
Appreciate that. Thank you, Madam Chair.
Thank you for being here, Ms. Carlson and Mr. Sitar. Can you maybe take a step back and run us through the practical? What does this look like in terms of you know, using this mechanism in a casino setting. I understand how with a brand new opening like Resorts World, there would have been delay because you have a lot of people setting up accounts at one time. But under a normal type of operations, I mean, those people set up their accounts at different points in time. You know, I don't understand the backlog on that. And then once you set it up, you can use it anywhere in the casino, correct?
Yes, Madam Commissioner, that is correct. So even in a non-resorts world, and that's an absolutely fair point, if you go on a Tuesday afternoon, as opposed to the opening of the first $4.5 billion casino on the Strip in a decade, it's a very different environment. We have experienced times of up to 40 minutes at Boyd Gaming as well. There are only certain employees that have been allowed to look at IDs and verify IDs. You require cage supervisor approval. So for example, if you went to Aliente and enrolled in the product as it stands today, in fact, I was just with another operator this morning and with our partners from Aristocrat talking about Boyd, that they just went a couple weeks ago and experienced about a 40-minute time frame. So what it really changes is it also allows the gaming operator. So for example, if you're someone who might be visiting from Reno or you're visiting from California, the gaming operator can now send you, for example, an email and says, welcome to our casino. You're coming and spending the weekend, and here's an email about all the offers that we have that's available this weekend, shows, et cetera, so on and so forth. By the way, we see you don't have our mobile app. Please click here and go ahead and download my mobile app. And once you've downloaded the mobile app, it guides you through the process of verifying your ID, creating that loyalty account, and then effectively putting money on deposit. So now when you're coming to the casino, you're just going straight through and enjoying the things that you want to enjoy. And that is really what it helps solve.
Okay, but the scenario that you described with respect to like Aliante being a 40-minute wait, I mean, that seems to be more of an operational delay because they've chosen to implement procedures that require a supervisor or particular person. Couldn't that be alleviated by having, operational changes in terms of who is allowed to verify that identification?
You are absolutely not incorrect. One could have more staff. One could have more people. So the idea is that you're enrolling into loyalty. So what happens today at Aliante is, if I'm a completely new customer who has not done this before, and I'm going to the cage and I'm getting educated on what the product is. I'm then going to the loyalty desk and I'm creating a loyalty account. And I'm then taking that loyalty account and I'm going back to the cage. I'm downloading the mobile app and giving my loyalty number to the cage. And the cage is then actually inputting my loyalty number in there. And now I am creating this account. I'm putting money on deposit, and now they're physically validating my ID. I am then going to a slot machine to go out and play. And so it's the back and forth that the person is doing between loyalty ID verification, cage ID verification, and then play is really what. So yes, sure, absolutely. If there were more people on staff and there was more process in place, could it be done quicker? Yes, it could.
Right. And I'm not suggesting that you necessarily need to add staff. It sounded like there was an operational decision made that it be certain staff that, of the people that are already there, that only certain staff could perform this function. Now, in the scenario that you just described, the back and forth seems to be, in a situation where you said they're getting the email and they're starting from scratch. From what I understand from the materials, a lot of that could be done prior to arrival, and if the only step required is to show their ID to get their ID verified. I mean, that should entail the back and forth, correct?
It shouldn't. I'll give you another Resorts World example. So even for ID verification, when there are multiple systems involved, there were one of the things Resorts World tried to do in order to alleviate the pain was put ID verification kiosks. And so the idea was that you could go to the ID verification kiosk, dip your ID, and that actually had a very high failure rate, and a higher failure rate than Resorts World or anyone else had anticipated. And so then staff had to be kept next to the kiosk in order to effectively for the kiosk to look at the ID, then the staff to look at the ID. And the way these systems are architected, Commissioner, is so there's a tie-in between the payments company, the mobile app provider, and the gaming system provider, which at Resorts World was Konami. And upon failure of the verification of the ID, what was happening is now everything was being switched to paper forms. So we reverted back to filling out paper forms for patrons, including putting social security numbers on paper forms and submitting to the cage. Now it's a perfectly secure process, and it's just what happens when you take people through that process is in the conversion funnel of the people who first indicated they wanted to try this new product to the ones that actually end up trying it, as opposed to 20 or 30% of the people trying it, you might have 2 or 3 or 3% of the people trying it because it was too much hassle to actually go through all of that. And, so yes, I mean, could someone enroll for everything in advance, and could they come and show their ID in person? Yes, they could, and that is certainly possible. Our position has been that ID verification, remote ID verification, is used so extensively, has been in Nevada, is used for other forms of gaming across the country, is used by us as citizens of the country for many things that we do, including the opening of bank accounts, brokerage accounts. So that same technology should be applicable to cashless wagering in the state of Nevada.
Okay, with respect to the identification kiosk, I mean, that seemed logically to me like it should have, if they'd done everything ahead of time and just brought their ID to the kiosk. What was causing this failure that you're describing?
Just so I don't want to speak on behalf of the company that was providing that kiosk. It's another vendor of Resorts World, so I'm not entirely sure what was causing the failures. I can tell you on remote ID verification, we generally see in the core of our business and what Sightline does in also in the non-cashless world. We operate in 39 states right now. We roughly see on first pass ID enrollments, roughly approval rates that are close to 90%. And what that means is that if we cannot verify your ID electronically after if you uploaded your ID or given us non-documentary evidence, which is your name, address, date of birth, and social security number that we verified with the third party, and now we come back to you and ask for additional information. That additional information could be a utility bill. It could be all those more traditional methods that you are used to. And until that full KYC is not complete, your account is not created. And, whereas in that digital format, we run about a 90% approval rate. And as I understand, the approval rates with the kiosk are running somewhere in the 60% range. Again, I'd rather not speak on behalf of the company, so I don't know why the failure rates were. But from a process standpoint and a patron experience standpoint, and it was difficult and cumbersome.
I just add one other clarification as well, and I think Omar brings up a good point regarding the customer experience. Currently, you could do all of these steps remotely and then come into the casino and show your driver's license to a person at the cage, whether or not they need to be a supervisor level or not. Obviously, that's up to the operator. But that's a one-step documentary evidence process. What we're proposing today and the language of the board would be actually a two-step process for remote verification, which actually provides more safety for the registration of the account. You're utilizing your documentary evidence, but you're backing that up with a secondary method, which could be another document or non-documentary KYC. So you're actually adding a step for verification with the language that's in the board's in the board recommendation by adding that additional safeguard in a way that currently you have someone looking at an ID, verifying that it's the person and handing it back. And this is actually a safer method for the establishment of an account.
I'll defer any further questions at this point.
Commissioner Cohen?
I'm troubled by the failure rate. And again, you're saying we don't know exactly why or how, and it would have been a third-party vendor. Ultimately, I think what we're charged to do is look at both, is it good for the industry, is it good for the patron? Tell us why this is so good for the patrons, and how are you going to handle the dissatisfaction, if there is dissatisfaction, with the wait lines, with the failures, and then you throw up your hands and say, we couldn't do it.
This is hugely beneficial for the patrons, and everything that we build and design. And when we spend time with whether it was AGM or the Nevada Resort Association or the American Gaming Association or the Nevada licensees you know, on this ecosystem, on this product, is designed with the idea of patron first, whether it's a Nevada patron or or one of the tourists that we love to have over here. And what is the patron experience and what is the patron satisfaction? And, what I was alluding to earlier, the issue that happens for anything that the patron wants to do, if the patron has to go through many steps in order to do something, that makes it more difficult for the patron, and there's a lower adoption rate. That is perfectly natural for us as humans in everything that we do. And we know that as the pandemic hit and the casino shut down in March of 2020, by May of 2020, Commissioner, we were getting phone calls from casino operators, not just in Nevada, but around the country, asking the question, how do we safely and securely reopen our properties and allow our patrons the ability to interact with something that other than cash? Right? We're not saying cash is going away. We think cash is going to be with us for decades and decades. And but how do we give that option? And so the first response to that was there are now safe and secure and responsible technologies for your patron where they can create an account that are effectively these very safe and secure FDIC insured accounts. They can deposit money into these accounts using many methodologies that they like, including cash deposits. They can deposit them from their bank accounts, and then they can use that money at slot devices and tables. And that cashless momentum discussion progressed very aggressively with casino operators around the country and in Nevada. And so then the question was, well, the devil's always in the details, right? So what is the consumer experience? Exactly the right question you asked. What does the consumer see? What does the consumer do? What does the consumer touch? And what if the consumer doesn't have a smartphone? And how do you educate the consumer on, is this truly safe and secure, right? Like I mentioned in those 4 things that are important to a consumer, what is the most important thing, right? Why should a consumer put money on deposit with me, the casino, in order to then come and wager? Do they genuinely feel it's safe? And so in architecting this entire ecosystem with the resort operators in Nevada, you know, that question of building out the flows of what does the consumer have to do? And ID verification was the one place where it kept coming back to saying, how do we digitize that? How do we digitize that? And in part of the board discussions and part of the change that the board recommended, which I think makes a lot of sense, was, you know, let's also capture ID. Let's not just take non-documentary evidence. And what Ms. Carlton's referring to, non-documentary evidence would be like you giving me your name and your address and, you know, date of birth and social, and me going to a third party like LexisNexis and validating that and coming back and saying, all right, I know a device ID from a mobile device which is owned by gentleman XYZ. I've also validated all this information of where this person lives. Maybe they've answered some knowledge-based authentication questions, such as where you went to high school, what your pet's name was, so on and so forth. But let's take it a step further. And the step further is you actually are now still providing your ID, whether it's a driver's license, a passport, and that's going to be scanned into the device, no different than how you would load a card into an Apple Pay or an Android Pay. And so we've got your ID, we've taken the non-documentary evidence, we've validated and verified all of that. We've done it in real time. Now, nothing's perfect. And that's what I said about enrollment rates. So if for some reason there's a mismatch, let's say I get back something from the DMV, or we get back something from the DMV, or we get back something from a third-party database that says, well, we couldn't really verify whether this gentleman lives at this address or at this address. And now we have cause for another discussion with you. That discussion could be over the phone, it could be face-to-face, it could be at a casino, and that discussion would be, well, we tried to verify your ID, we were unable to verify your ID, can you please provide us additional information? And here's the information that we're looking for. And so we actually think the system is more safe, more secure, but it makes it easier for the vast majority of consumers to actually try real cashless wagering in the state of Nevada. And so it is all consumer centric, what is being built, and that's hence the request for the reg change.
Thank you.
Welcome.
Commissioner Brown?
I'm not sure that I'm 100% comfortable with this process, only because I think, and tell me if I'm wrong, under the proposed amendment to Reg 5.225, the proposal is that a patron can make a wager without ever coming into the casino and having a human being verify that this is the ID I pulled out of my wallet and this is me. Is that correct? Am I understanding it from a very basic premise? Yes or no?
Yes, a patron could place a wager in a casino without ever having shown their ID to a casino employee. That is correct, Commissioner.
Okay. And so I keep hearing words like hiccups and issues or safeguards. And safeguards, I think, are very important because we don't want any minors or people who aren't the people who they purport to be with an ID. So could you please give me one or two examples where somebody's been able to circumvent the safeguards that you have in place and either use an ID that didn't belong to them to actually set up an account where there was no in-person verification? Has that ever happened?
Can
Go
I,
ahead first.
yeah.
Yeah.
I just do want to clarify that this system that we're proposing already has been active in Nevada through interactive accounts. So if you were sitting at home and you wanted to utilize our interactive wagering account system in Nevada, and you signed on to an account, you would verify your identity remotely and you would never step foot in a casino. You could wager from your home. So essentially what this is doing is providing that same level of security for you. So you don't have to go into a casino to present your ID, but you do have to go into a casino to wager. So it would be essentially take logically that next step of the interactive wagering, how you already set up accounts in Nevada, and moving it to in casino wagering, where you could verify your ID remotely in the same way that you do right now for interactive accounts.
And to directly answer your question, we are not aware of, so Sightline as a company, I obviously can't speak for other companies, but we have been verifying IDs remotely since 2012. We are not aware of any such incident. Now, we work often, as the board and the commission might know, with in many cases with law enforcement, as does gaming, as do most gaming operators. And but verifying of IDs electronically is in fact a very safe and secure system. And the hiccups I was referring to was to the commissioner's question about, in particular, what happened with Resorts World and with Boyd, and we're actually trying to alleviate those hiccups. And but we are not aware of, and with the dual authentication, again, commendment to Chief Barbie and to Dag Sobs for adding the dual authentication, between actually capturing the ID and also doing the undocumented evidence. We don't believe that there is going to be an issue with underage gaming in the state of Nevada. And to Ms. Carlton's point, I mean, the person is still physically coming into the casino, and if it looks and feels and smells to the casino that this person is underage, they should certainly be stopped immediately from playing and doing so.
And has there been a single incident of a fraudulent identity in all of the years that you've been doing this?
Yeah, I mean that's a it's a very difficult question to answer. I think we've created across since Sightline's been in inception, we've probably created well north of 2 million accounts. And so the answer to the question, has there ever been a fraudulent ID? I would be, it's like in all technology to say everything is perfect. I would be lying, so I don't want to do that. And could there have been? There certainly could have been. Has there been any incident that we're aware of? We are not. And needless to say, we're regulated in a few dozen jurisdictions now. And if and when there's ever an incident, it has always been reported. But I'm not aware of any, ma'am.
So not a single incident has been reported
Of a fraudulent
Yes.
ID, of people trying to defraud us, absolutely, and there's no doubt about it. And and that happens in other jurisdictions, in sports betting, in iGaming, like I alluded to. I mean, if like in all technology, someone can try to defraud you. They can, no different than your credit card and your debit card. We put many safeguards in place, just the way your traditional banks do. And so have folks tried to defraud us? Yes, as they try to defraud gaming operators as well. And but falsification of IDs that we're aware of, especially for underage, I am not aware of anything.
And I mean underage or anything.
Or anything,
Yeah.
right? I mean,
It means somebody doing the remote verification of an identification, not having a third party, being a human being on premises to say, oh, that's not Bob, that's Jennifer, by way of example.
Yeah. I am absolutely not aware of that. And just to give you an idea of safeguards, since we're talking about it. So in payments, there's a number of checks that we want to do. And so when we are verifying your ID, and this is the reason I gave the example of the home address. In fact, this happened recently with a Boyd Gaming executive who was enrolling in the ecosystem and his ID was not verified. Well, we did a little investigation and found and to see why the ID could not be electronically verified. Turns out this gentleman has 3 different homes and all 3 of them are in different states. And so his credit card and his debit cards were registered to a certain home, and his ID was registered to a different home. And in the backend database that was tracking that was not linked together. So that's an automatic red flag for us, right? To say, wait a minute, this doesn't sound right. And you have a home here, you have a home here, you have a credit card here, you have a checking account and a debit card here, but your home, your address and your ID is someplace completely different. That's a red flag. And, so those are the kinds of the red flags that we run, which are very similar to banking ecosystems. And so especially knowing where the person is when they're funding that account, and then verifying the address. So for example, if your registered address with Boyd Gaming or Resorts World or whichever casino deploys this technology, is here in Las Vegas. And if your debit card address is different, the credit card address is different, and that's something that we actually don't allow you to change on the fly. That's something where you have to come in person and change, even changing PIN numbers and accounts. There's dual factor authentication around that. So there are a lot of checks and balances, but I am not aware of the kind of ID fraud that you're asking about.
Okay, thank you so much for clarifying. And have you received any opposition to regulation to 5.225's amendment? And if so, what is the biggest opposition and what's your response to that?
As you all know, we initially filed this petition in the fall of 2020. And at the time, we had not really, I think, adequately informed the operators of the purpose of this petition. And so we had a lot of questions. We subsequently held a lot of calls. Of course, at that time, with COVID, it was all calls, meetings with executives to really walk through what the purpose of the regulatory change was. A lot of people still had some nervousness about including sports wagering as a change to Regulation 22. So we voluntarily removed that piece and just moved forward with the change to Regulation 5.225 to make it consistent and parallel with the Regulation 5A that already exists.
Before you proceed, what's the trepidation with the sports betting? What's been voiced to you? What's the concern?
It's a very good question, Commissioner. So the concern with sports betting is Nevada obviously has hundreds, if not thousands, of different casino styles and games over here. The industry invests billions and billions of dollars in building physical buildings, and we want people to come to our casinos and avail themselves of all of that. The fundamental concern has always been, and there's some very good sports betting operators, for example, in Europe. The concern has been that if it's full remote ID registration for sports, a really big, well-funded European company is going to come to Nevada, is going to buy a small casino in Reno or someplace else and get a license. And I don't know. I mean, I don't know. I don't know. Yeah, I don't know. I don't know why I just did that. And, all right, so someone's going to buy a small casino. I don't know, maybe I don't spend enough time in Reno. Someone's going to buy a small casino, and then they're effectively going to compete. Elko. I hope no one's here from Elko.
No one's offended.
No one's from Elko. This very well-funded European company is going to compete against MGM and Wind and Caesars and William Hill and our local companies, and they can do it very effectively by investing nothing in Nevada and just buying the small casino. And we completely understand that and agree with that, right? And that makes sense. That hurts Nevada and doesn't help Nevada. And so that's why we wanted to make sure that sports was not included in this. And once we had this discussion with the industry and our partners at William Hill and Stations and others, we had this discussion and we said, you know what, you're 100% right. This makes sense. Let's change it. So that's when we polled and then spent time, like I mentioned, with all the industry participants, with the operators, with the Nevada Resort Association, to say, what can we do that actually helps the state and helps the patron, and do it securely, do it in an existing framework that has actually worked for Interactive for poker, and what that's going to mean for the state. And so hence this where we are now.
And as you'll probably recall, during the first workshop, there was some preliminary questions raised by station casinos surrounding the FinCEN guidance that had come out in October of last year, and specifically around whether or not this proposed reg change was consistent with that guidance. And so I know Member Pizarros did some research on that and reached out to various federal agencies. We also obviously filed some responses related to the guidance, but I mean, the key to moving past that opposition was the board amending the proposed language to include documentary and non-documentary verification, so that we weren't just relying on non-documentary verification. Once we had both of those pieces, it's very clear that it's consistent with the FinCEN guidance, and station withdrew its opposition.
Okay, so you have no pending opposition. And when I say opposition, I mean informally in the industry. The station's issue has been resolved. Is that accurate?
That's correct, and we have no pending. And in fact, that's venture to say the vast majority of the operators, we hope, and I think you will expect to see product built around this deployed all across the Las Vegas Strip.
Well, I commend the presentation today has really been very informative, and I appreciate the thoughtful responses that you've provided, just to make sure that we understand exactly what is being proposed. And I think to have intellectual honesty to make sure that, to the extent there are oppositions, you've addressed them, you haven't just, pushed them to the side, is very helpful to me, at least, so that I can proceed with my vote. Thank you.
Thank you.
Chair Tagliati, could I interject here real quick? I just want to clear something up, if that's all right.
Thing that was he just said, so that timing wise, you said you consulted with and had discussions with the Nevada Resort Association, and so in addition to stations who had their concerns at the time of that workshop, you're saying that none of the operators, after these discussions and these changes and these considerations, have voiced any additional concerns, including the Resort Association.
Yes, Madam Chair. So I personally have had discussions. So our Sightline's existing customers, not necessarily obviously for cashless, but for other products around sports and iGaming, include from the larger licensees in the state, include everyone from Wynn Resorts to Caesars to BetMGM, and we have had extensive discussions with Boyd Gaming, and in fact stations like, in fact, just it's somewhat ironic, Stations was the very first casino customer of Sightlines. They've been our customer, I believe, since 2013 maybe, and so we've spent time with it. I personally have spent time with probably about a dozen casino operators and across the state, and having this discussion, and there is no opposition. And Boyd Gaming unfortunately could not be here today to support. They were here during the last with the Gaming Control Board meeting, but there is no further opposition as far as we know.
Okay, thank you very much.
Thank you for that. I just wanted to, well, we can set aside the dismissive tone of Reno, but there was a couple of comments that were made, and I think I might even have used the word hiccup as well in regard to the example that Mr. Sitar was giving with respect to Resorts World and the kiosk. That was not a failure. So for the record of the process, it was a failure of the device. Kiosks have been used and still are used for verification methods. Also, in terms of the ID, that was something that even before getting the opposition to the initial sort of petition, we had already planned on including that documentary evidence being needed, meaning ID coupled with the verification process. That's different than some other markets where they may not require the ID, and that's another level of security that's embedded into our process as a way to ensure there's not going to be fraud. There will always be attempts at fraud. Fake IDs, of course, are regular. Individuals try to use that all the time in casinos. And of course, we rely on the folks within the casinos to be able to spot that up. Process that we would be implementing here is no different than what we have for Reg 5A, except that when we parallel this to the brick and mortar, we now have an automated process behind the verification process, an engine that's proven, frankly, in all other industries, searching those databases, Experian, Equifax, public databases, et cetera, and it's happening in real time. It removes the friction for that sign up process and still requires the individuals to come into the casino anyways. If we contrast that to the sports wagering side of the aisle, where Mr. Satar was explaining that they could do this remotely continually. And that's really the distinction between the two there. So I just want to make sure we cleared that up.
Thank you for that. Appreciated. Do any of the commissioners have any questions for any members of the board or?
May I ask a couple follow-up questions, Chair Tagliati? With respect to just following up on the question that Chair Tagliati asked as far as you consulting with the Nevada Resorts Association, and you mentioned you've spoken to licensees. I was a little surprised with how little participation there was at the workshop. I mean, generally the licensees aren't shy about expressing their view one way or another. And we don't have really much in the record in terms of, people speaking out in support of it, people speaking out against it for the most part. I understand Sightline's position that this is necessary and this is something patrons, need and want. But I guess I'm a little uncomfortable with the absence of any feedback from anybody that is supposedly.
I believe Boyd Gaming had submitted something in writing.
Yeah.
I mean, we did not affirmatively, after the discussions that we've had and been having with the licensees, knowing that there was no opposition outside of stations, and we did not ask for affirmatives. I don't believe so from the licensees. I'm quite certain if we had asked them to submit those in writing, they would have been. But for the vast majority of licensees, this is something that makes complete sense. And then the stations, obviously, you saw their position. So maybe that is something that we were remiss on, and I apologize about that, of not affirmatively asking more licensees to put something in writing. But this is something, and the reason, Commissioner, when you asked the question of when this would be ready, I mean, and the reason it would be ready as soon as March from a technology standpoint is because certainly our existing partners like Resorts World and Boyd, who have cashless technology deployed, just from a technological testing and building of the technology standpoint, we've been working on it for months together, and with the hope and the anticipation that the regulatory change is going to be done so it can be out and market quickly. But that's something that we are clearly remiss on, and I apologize about that.
And again, I mean, I still have underlying concerns just about the need for it. It just seems like giving up the in-person verification to me is a big step. I realize that it's in a casino, so if they're already there, I mean, Nevada, unlike other jurisdictions, our casinos are large and there's multiple cashiers cage and there's multiple kiosks, so it doesn't seem like that much of a convenience issue, and what we're giving up to me is significant. I know even with a dual verification, I know the information for probably 10 people that I can think of off the top of my head where I have their ID and I could answer any verifications with respect to that. Not that I would use it for any nefarious purpose, but I'm just concerned with information getting into the wrong hands, especially in this era of identity theft, when it would be so simple to just go verify at a casino cage or at a kiosk or anywhere, anything like that. So that's kind of where I'm at. And I'd feel better if the industry was saying, hey, no, we're comfortable with it. I mean, they obviously are in the position where they have the most to lose. So if, they had expressed an interest in it, that would carry a lot of weight with me, because they would have, really thought through all the procedures and looked at what procedures would be required and determined is it worth risk benefit. So that's just where I'm at this point.
Appreciate it. Thank you.
Is there anyone else who has any comments or questions? I mean, I guess the flip side of that coin is none of them are here showing concern.
And that's what I was alluding to, that I mean, certainly when listen, I mean, from our standpoint, if there was concern, we wouldn't be here. And I mean, we made the mistake once already of being in front of the Gaming Control Board with something that the industry did not support. And once we sat down with our partners in the industry, we have about 10 Nevada licensees that we work with right now. Once we sat down with our partners the previous go around, we decided we had made a mistake, and we immediately reached out to the Gaming Control Board and said, let us do more work and come back to this. And so you're 100% right, Chair.
Well, it's my observation, at least as far as I've served, that I do recall early on there was an issue with the Kentucky Derby and contractual disputes, and people were very vociferous and they were not shy. And if to the extent they had an issue, they had the opportunity to voice their concerns, and they did so, and they availed themselves of that opportunity. So I don't have any issue with due process. I do echo some of the concerns regarding actual need. And I know that you gave the example of 40-minute wait at Aliante, just by way of example, but I'm just not sure the convenience and efficiency is the biggest concern. To me, it's the safeguards and protections. And so I'm not seeing why the in-person verification is so inefficient or so inconvenient. And to me, the safeguards are super important. But it also, at the same time, I have to juxtapose that with the fact that there's nobody here kicking and screaming saying this is terrible. And it seems that you've addressed the issues. But I'm still struggling a little bit with the actual necessity compared to the safeguards. So
I know Commissioner Keycapper has a comment or a question.
Yeah, thank you, Madam Chair. I see this reg um, as very sort of consumer facing, right? And as we balance the need for intense integrity um, in, in some of these processes with the ongoing need to stay sort of modern in our technological offerings to the consumers as they come into our state, our facility. I think that this reg makes a lot of sense because um, I mean, sometimes when we sit here, we can think that one extra step of, okay, now I show up at the casino and now I have to go stand in line and find the cage and go wherever there. It may not feel like a burden, but I think to consumers it can, and and to our customers it can, and it's more time that they have to spend um, not having fun, right? Uh, uh, and from the integrity standpoint, this is the same technology that lets you take out a jumbo mortgage. And if we're allowing people to access that type of credit on accounts, um, then I think from an integrity standpoint, we also rely on it to know that that the identification will be securely verified, and that on top of that, this is a player who is physically in the casino, right? This is someone who's there. It's not a shadow person. It's not a mystery, and that when you combine all those factors, this moves us in a positive direction of supporting where consumers want to be and maintaining the integrity that we expect.
Thank you for that, Commissioner. One point just to, based on what you said, and Ms. Carlton just mentioned this to me. We generally don't share these numbers, but now that we're having the frank discussion, so basically in electronic payments, as industries have converted away from cash and to more electronic payments, and generally you see the consumer spend somewhere between 12 to 18% more money. And that's a very natural inclination for the consumer to do that. And that even includes on tipping. And so as you see, as you go to a coffee shop or other places and you see kind of those new point of sale systems that even on tipping show, hey, if it's a wow service, you hit 30% or you hit 20% or 18%. Well, turns out a lot more people now tip 30% than they used to previously. And so conversion to electronic payments with an ease of use is what drives adoption. And the concern with the operators, and especially the really large operators, the large commercial casino operators that have presence in the Strip, but also across around the country, is that in order to convert systems over, and that's one investment in technology. But then there's a very human investment in technology, right? If you are a casino company that has millions of people that visit you every single year, you have frontline employees that are tens and thousands of people that you're training in new processes and in new products. Not dissimilar to what happened with Tito when it was introduced 20 plus years ago, where the introduction of Tito was very difficult and cumbersome because it was introduced on partial casino floors. So patrons thought that, oh, Tito is something different than coin machines. I'm confused. They were putting coin in slot machines. The point being that that took a massive investment by the industry to re-educate frontline employees. So for the large casino operators to invest in technology, not just hardware, but software and training their tens and thousands of employees, on the flip side, they need mass consumer adoption. If something causes a lot of friction and the consumer adoption rate is 2 or 3%, well, then that doesn't justify the investment. And then because you also then don't see the lift in play and the lift in spend that you're hoping for. And now, if you can get the consumer adoption to 10, 15, 20%, now that starts to move the needle. The example that we have spent a lot of time, and actually the industry has spent a lot of time, is learning from is Starbucks. And when Starbucks first started deploying their mobile app, they did it very much the way a casino is contemplating it. It's a completely closed loop ecosystem. They deployed it at a few dozen stores, then put in the hardware for a few hundred stores. By the numbers now, about 25% of all Starbucks transactions in the country now are done on their own mobile app. Starbucks, if it was a financial institution, would be a pretty significant bank. They'd have about $2.5 billion in deposit. And that's effectively a Starbucks customer telling Starbucks in advance, I promise to come back to you because I put money on deposit with you. And that has a massive interchange expense savings for Starbucks. It has more spend. It drives more loyalty. And that's the same benefits that the casino is hoping to derive. But the investment in technology with potentially a very low adoption rate doesn't make sense. So, and that's why removing the friction piece is so critical. And the safeguards are critical. I mean, one more piece, but I would just mention about at least from the sightline perspective, what we do. Yeah, we work with bank partners, and so everything that we do, our customer information program, the KYC, the AML, it's no different than as if you were walking into a bank in Nevada and opening a bank account. And we get audited by the FDIC, we get audited by the FFIEC, the Nevada Department of Banking, and so there are many safeguard security procedures in place. And hope that addresses the question.
I did want to add one thing to what Omar alluded to, and maybe you saw it this morning. There was an article that just came out about Iowa's sports revenues. And for 2020, they did not have remote identity verification, and their handle was around 500 million. They implemented remote ID verification for the same product, but it's now you can verify your identity remotely for 2021. It was $2 billion. So the adoption significantly increased, the revenue handle and for the state significantly increased because of the ability to verify your ID remotely. So there are certainly some very real world examples of the utilization of technology to verify your identity remotely and how that actually impacts handle and play.
Thank you.
Thank you, Chair. Talk about being on the fence. I am absolutely on the fence on this. I mean, to the point of I'm almost agnostic. I don't care whether it passes. I don't care whether it doesn't. Now, what gives me comfort is the fact, and I'll use station casinos because they've been bandied about. They've had the opportunity to participate, and at least what we, have seen, the only thing that Rubenstein has objected to, and he walked that back, to some extent, was the FinCEN issues. Now, I also know that the Nevada Resort Association, it's public knowledge that this reg is out. No one is here to protest. There is anecdotal evidence, as council has stated, that these type of things enhance the ability for people to register, enhance the ability to bring money into the coffers and make gaming easy. That's why if I was forced to vote, I would say give it a chance. But likewise, I just don't know that it's needed. And again, the only reason why I'm saying it's agnostic, I just truly don't know if it's needed. But I don't know, at least from my particular standing, is whether or not that rises to the level of not letting it try. If it fails in the marketplace, so be it. If you have a whole lot of people who are, filing complaints and coming here during, the public forum, so be it. So, with that said, depending on the motion, we'll see how it goes.
I have a quick question for the board, Chair. For the post-certified law enforcement gaming officers that work for you, who presumably have, obviously a vested interest in the minors gaming and fraud and other things that can occur. First of all, do they have the opportunity to express to you any concerns they have about any change in a regulation like this? And if so, has anyone?
Madam Chair, I haven't held a roundtable with them, but in conversation with the chief, he's, I think, forward thinking. He understands the framework well. He's an expert in anti-money laundering provision. Yeah, the framework that he's looking at this through and that I look at it through is Title 31. So Title 31, which is, I mean, you could do more than Title 31, but that is the minimum requirement, federal law, right? Bank Secrecy Act. So you've got documentary evidence and non-documentary evidence. Non-documentary evidence, I mean, it's not just name, social security number. They're pulling your credit report and they'll ask you, how much you owe, X amount on your Toyota Prius. I mean, information that other people shouldn't know. That's non-documentary evidence. What FinCEN has said is that for internet gaming, they've allowed, through a special dispensation, allowed for non-documentary evidence to satisfy identity verification. Now, in the case of brick and mortar casinos, what they're saying is that because the regulations that have been drafted do constrain them, unless they're amended, constrain brick and mortar casinos to the use of documentary evidence, that's the way it has to be. So what we have here is we have establishment of account and identity identity verification that will include both the higher standard required of brick and mortar casinos and the additional benefit of requirements under Title 31 Big Secret Act for iGaming. So I think I just don't know what more you could ask for. I mean, the concept of appearing, that happens to be the case, but that's not documentary, non-documentary. That is the framework.
Does anybody have any additional questions or comments before?
I will say it gives me some substantial assurance that, of course, this has been vetted by the board and that you appear to have a comfort level with it and, supported it. So I do defer tremendously on topics like this to the board because I know that you vetted it, you've been involved in the process. So I thank you again to the board for expressing some clarification and some more insight today. It's been very helpful to me.
Okay, so at this time, any other questions or comments? And Commissioner, have a motion, anyone?
Despite my being on the fence, I would move for approval of the proposed amendments to Regulation 5 as set forth in the draft dated as of September 17th, 2021, to be effective on the conclusion of today's meeting.
I'm sorry, the November 24th?
December 17th.
December 17th. Okay, so that includes the valid language.
Yes.
Yes. Okay, so any discussion on the motion made by Commissioner Cohen? There being no additional discussion, all in favor say aye. Aye. Were there any opposed? None opposed. Thank you very much.
Thank you.
All done.
Good luck.
Very much.
All right, next on our agenda are the administrative reports. Let's start with Chair Gibson. Do you have anything?
Hello, Madam Chair. So February 2nd will be our meeting. It'll be a one-day meeting starting at 9 o'clock. We'll run our non-restricted section items from 9 to noon and start the restricted at noon. And so we'll try to finish that up in that day.
Okay. Anything from our Attorney General today?
Nothing today, Madam Chair.
Thank you. Madam Secretary, let's close with our last agenda item, public comments.
This item is placed on the agenda to give the public an opportunity to comment on gaming-related matters.
All right, I'll first go to Carson City. Anyone wishing to make a public comment, please step forward to the podium.
It's
Here's,
my understanding there's no one in Carson City.
all right, there's no one in Carson City. Anyone in Las Vegas? No one in Las Vegas wishing to make public comment. That will close our public comment section. This concludes the Nevada Gaming Commission meeting for the month of January. We are adjourned.